Thank
you, Pauline.
The meeting of the Hawaiian Homes Commission is called to order. The meeting is being held interactive via interactive conference technology, moderated by me, William J. Isla Jr. Today's date is Tuesday, September the 21st, and the time is 9:35 a.m. Pursuant to Governor's proclamation relating to the COVID-19 emergency, Hawaii Revised Statutes, Chapter 92 regarding public agency meetings and records is currently suspended through October 6, 2021, to the extent necessary to enable boards to conduct business without holding public meetings open to the public and to allow state agencies the ability to effectively and efficiently provide emergency relief and engage in emergency management functions. At this time, we are able to live stream the open portions of this meeting via the DHHL website. I'm going to just briefly remind everyone about Act 220, the remote meeting by interactive conference technology. So for the open sessions of the meeting, commissioners, please say who's in the room with you, if there's anyone in the room with you. Keep your camera on unless you're excusing yourself from the meeting. A quorum of commissioners must be visible during the meeting. In executive session, no one can be in the room with you or to be able to hear the conversation. You will need to confirm this to the chairman. In executive session, you do not need to be visible, so you can turn off your camera if you want. Leah, would you please call the roll? Was there a question?
Yeah, I have my wife in the kitchen, just to let you know.
Oh, thank you. Zach. Leah, would you please call the roll?
Commissioner Awo will be a little late. Commissioner Helm,
Here.
Commissioner Kahu,
Aye.
Commissioner Kalekini,
Aye.
Commissioner Kaupu,
Here.
Commissioner Namuo,
Here.
Commissioner Neves,
Aye.
Commissioner Teruya,
Aye.
Aye.
8 members present. We have quorum.
Okay. We have quite the carryover agenda, so we'll start with public testimony.
Ready?
Yes. Is Mike first?
Mike is first.
Okay. We'll let Mike Hodson in. There it is. Okay. Mike, we see you, but you're muted. I can see you, but you're muted. We can't hear you. All right. Still can't hear you, Mike.
How about now?
Okay, awesome.
Oh, am I up?
Yes, you are. We can hear you.
Oh, sucks. I was waiting to get connected for a while. Okay, mahalo. Mahalo, Commission. I don't like to take up too much of your time, so I wrote out my statement. So I'm presenting on behalf of Hawaiian Homestead Association in regards to the lease at Punanaleo. So Hawaiian Homestead is an organization, is organized as Native Hawaiian Homestead Community Development Organization for the benefit of all Native Hawaiians as defined under the Hawaiian Homes Commission Act. WHHA was established in 1952 for the purpose of organizing our Kanaka of Waimenui, to have a voice in our Ahupua'a and take an active role in how our community is developed. In a list of 8 principles and purposes, perpetuating our culture and educating our people in the ways of the Kanaka is well stated. In understanding the duties of the commission to act exclusively in the interest of the beneficiaries, hold and protect the trust property for beneficiaries, exercise such care and skill as a person of ordinary prudence would exercise in dealing with one's own property in the management of the Hawaiian homelands, and adhering to the terms of the trust. We believe that the purpose of both Waimeanui's WHHA board and the Hawaiian Homes Commission is a coexistent relationship for the same purpose. The rehabilitation of our people to bring us back to what we once were: socially acceptable, free to practice our culture and cultural beliefs, economically self-sufficient, highly educated, and politically self-determined. WHHA has over 50 divisional board members in 8 divisions, a 9-member Homestead Executive Board, a 9-member Waimenui Council, and a 7-member Ahupuna, with a voting membership of over 500. Beneficiary consultation. Policy requires consultation to be exclusive and respectful. Efforts will be made to identify, invite, and encourage beneficiaries and stakeholders to be involved early in the planning process. Consultation requires proper outreach to the right people at the right time. Early beneficiary consultation allows careful and respectful consideration of their input, feedback, ideas, and visions. The leadership of land management and land planning was very diligent in reaching out to our community of beneficiaries to gather information and learn more of our homestead community. Tasked with researching the lands in question and the requested lease of our lands, I conducted an investigation and made it available to you in a beneficiary consultation process. I hope you guys have that investigation. Beneficiary organizations throughout the state are organized by districts, communities, or ahupua. It is inconceivable for either the Hawaiian Homes Commission staff or staff at DHHL to know the working mechanics of these regions with the limited manpower and a commission of 9. The needs and wants are different throughout the state, and there is no cookie cutter program that will meet the needs. It must be organic. We must be involved to fulfill the mission of our prince. The homestead beneficiary organizations are your eyes, your ears on the ground. We must do this together. Generational knowledge of our lands, traditions, and customary practices are embedded in our individual communities. So hear our voice. Punana Leo brings to our community value, not just in education and childcare, for other entities do the same thing, but brings the teaching of our language, the teaching of our culture, the teaching of our customary practice, all of which falls within the mission of the Act and in line with both WHHA and the Hawaiian Homes Commission. Punana Leo is not Kamehameha Preschool, funded by the biggest trust in the state with Bishop Estates. It is not a public charter school that is funded by the state legislature. It is a grassroots organization of Native Hawaiians with a vision to perpetuate our people in the ways of the Kanaka. Their financial resources are limited. The cost to our people to attend is very low. It's a labor of love. It's taking kuleana, and we applaud the school for taking kuleana. In spite of so many obstacles they constantly face, they persevere. So let us join them. This is the findings of the beneficiaries of Waimenui, your eyes and ears and the heart of your people. Gratis is the recommendation of Waimenui for Punana Leo. Mahalo.
Mahalo, Mike. Commissioners, questions for Mike? Okay, thank you for that
All right.
heartfelt.
Aloha.
Mahalo, Mike.
Have a good day.
Aloha.
Aloha.
Yeah.
Next up is Kiko Inamoto. Aloha, Kiko. Okay, you're on mute.
Aloha, Commissioners. I'm Keikoa Inamoto from Maui.
I'm Norman Apehai from Maui also. Aloha.
Aloha,
And-
Norman.
And we're on my homestead here at Waiahuli. You can see my Dorset golden apple tree in the back, and this one over here is the Anna red apple. We want to say hello, and it's the advent of our fall season up here in upcountry, and it's a beautiful overcast day. And so last week believe it was Thursday. Was it Thursday? Norman invited me to go on his mule, and we did native access to the 5,000 acre parcel, Waiahuli Keokea Homelands Tract that is below our homestead. And so I did forward some photos from that huaka'i. I don't know if Leatrice is able to post them for your edification, but I forwarded 13 photos, and so I want to let Norman talk about what we saw and did. Go ahead, Norman.
Good morning, Mr. Ayla.
Aloha.
Last week we went down to the 5,000 acres because it seems like you guys never do your job on the 5,000 acres. They're still on it. We got to we got some photos that we sent you guys to look at, because I want you guys to know that Kanaolo is stealing land from the 5,000 acres. And it seems like you guys not even interested in doing anything because you guys never do nothing yet. They got the water trough in there. They got the electric fence up. That's the one they're stealing the maybe 1,000 acres. So I mentioned this about a couple months ago, and still no action has been done. They got the cowboy gate hook up at one corner where they can access in and out of that cowboy gate. And at the bottom of that fence line going down, there's a double gate that they access in and out. And right at the double gate, there's that electric fence line that they're squatting on. So if you guys not going to do your job, we're going to step up and do them for you. And I have another concern. That's the first concern. The other concern is we sent Hawaiian Telecom, whatever.
So Sandwich Isles Communications and Hawaiian Telecom. Yeah.
Yeah. So what I like to know is how come they got one right of entry? First thing. Second thing, I like to know if we were going to have beneficiary consultation. It seems like you guys can just pass us by without having a beneficiary consultation. All you guys, when agree to the right of entry without even letting us know. So I like to know what's happening. I like to know what's happening on Kanaolo, what you guys going to do, and what's happening with Hawaiian Tel. Mahalo.
So this morning I did call the ranch manager, Ken Miranda, who is a part Hawaiian of Ka'onaulu Ranch. And I left a voicemail message telling him that we were going to testify. You know, I wanted to hear from him what their intention is with that fencing. And I haven't heard back from him, but I want to give you folks my impressions of that 5,000 acres. It is beautiful land. You know, it's when we saw all of the things, the miles of electrical fencing and the miles of PVC for irrigation and water troughs that Ka'onaulu Ranch has installed, Norman said to me, "Don't you feel angry?" I said, "No, I feel excited and I feel elated with the prospect of our homesteaders going on this beautiful land." Granted, there is a lot of cactus on it now, a lot of kiawe wood. But last weekend, we took a gentleman from Kapolei down there from Phoenix Carbon LLC. And he said that they have a machine that can convert the green waste, all of that kiawe and cactus, into fuel and into carbon. And I just was listening to Hawaii Public Radio this morning, and that is one of the big things that can help with global warming, is to have more carbon in our soil. So these are just prospective things. Uh-oh, the lawnmower is coming. And I enjoyed that trip down there, and I thought I came away with a lot of positives. We came on this side because the dog is barking on that side. Now we've got the lawnmower on this side. But anyway, the reason we're not indoors is because my son went for eye surgery to Oahu last week, and he has got COVID symptoms. So we're sort of in lockdown at my house. And so I didn't want Norman to go in there. Norman, did you want to say anything else?
No, I just need some answers.
Thank you, Norman, and thank you, Kekoa. And
Yes, thank you.
please stay healthy. So Norman, the answer to your questions on the right of entry. The right of entry is meant to be a temporary document. Hawaiian Tel, through the bankruptcy case, now owns buildings that are on Hawaiian homelands. And so the commission, the department needed to provide authorization for those buildings to be there so that they can provide continuation of services for what is called the middle mile. Okay, so Hawaiian Tel now owns what used to be Paniolo. They're providing signal all the way to those buildings, and then SIC takes from those buildings out to the homestead. There will be beneficiary consultations. It's clear from the record that when it comes time to negotiate a license with Hawaiian Tel, with any other telecom provider, we will do beneficiary consultations prior to issuing a license. Okay, so that's the answer to that one. I am frustrated to hear that there's still cattle on that land from the ranch. So let me take a look at getting staff to provide me with confirmation of the information that you have provided to us, and then we will take the appropriate action. So
we had a Pa'upena Community Development Corporation board meeting on Saturday, and several of the men on the board want to go put that PVC, the irrigation lines that Ka'ona'ulu Ranch is crisscrossing across our homelands. And I told them, maybe the ranch will donate it to our nonprofit, because that would be a tax write-off to them. So I asked them not to damage that.
I don't recommend damaging anybody's property, even if it is on our lands without permission. So, okay, so you made the right appeal to the men.
Mm-hmm. But the men are frustrated that this ranch, this 12,000 acre ranch, is absconding with 1,000 acres of our homelands to run its cattle. We just don't feel it's right. I mean, we want to see beneficiaries on there, not non-beneficiary 12,000 acre ranches on there, third generation ranches.
We are very clear at your position on this. So thank you very, very much.
Thank you so much, commissioners. Mahalo
thank you.
from Maui. Yeah.
Great day. Be safe.
Norman.
Aloha, ahuiho. Thank you, Leah.
Thank you, Auntie Kiko.
Mahalo.
We will turn to the agenda, and first item, let's do H1, and then we'll do H1 and then we'll do the regular. H1 and H2, the budget and transfer. Okay, we had a workshop yesterday afternoon from Rodney. Rodney, would you read the recommendation?
Good morning, Commissioners. Item number H1. It's recommended that the commission approve the fiscal year 2023 operating and capital improvement program budget request, which is the sufficient sum.
Cannot hear, Chair.
Sure, we cannot hear.
His mic is not
Here.
on.
Cannot hear.
Hold on, we'll test the mic.
What item are we on?
You're on H1.
Okay, thank you.
Item
Thank
number
you.
H1.
Got
Better?
it. Thank you.
It is recommended that the commission approve the fiscal year 2023 operating and capital improvement program budget request, that is the sufficient sums budget, presented below to the governor for consideration in the administration's executive budget request to the 2022 legislature. 2, that the commission approve the fiscal year 2023 operating and capital improvement program budget request, that is the sufficient sums budget, to be presented to the 2022 legislature. 3, that the commission authorize the chairman to adjust the operating and CIP budget request to make technical adjustments due to minor errors before it is incorporated into the administration's executive budget.
Okay, we have a motion to consider staff recommendation.
So move.
Second.
Okay, thank you. Discussion?
Yeah.
Yes.
I
Patty?
have, under the operating costs for administration, can we, I don't know if it's appropriate to add, to fund the 200 position of DHHL staff, Rodney, is it?
It
On
is,
page 2?
yeah,
Is it
the 12
described that we are priority to fund? I know we have the positions, but we want to fund the positions.
correct. So in this past session, Act 88 funded approximately $9 million for personnel costs. In this budget, we're asking for full funding of the 200 positions, and we're asking for $12.2 million. So
So
this
is
will
it-
fund
is
the
it-
200.
Is
Yes.
it described in this summary?
Yeah, it's
Okay.
actually it's described in this submittal, and it's
Okay.
also described in the summary too.
Okay, great. Thank you, Rodney. Thank you, Mr. Chair.
Thank you, Patty. I see Mike's hand up and I can't tell if anybody else.
Thanks, Chair. Just a quick question, Rodney, thank you. Were you able to find out the proposed employees for East Hawaii?
There's,
And if not, you can send it to me later. If you don't.
yeah, I can send it to you later, but offhand, there's only about 3 employees in that. It's 1, 2, 3. There's 4 employees. There's the manager, 2 clericals, and there's a
Clients,
well, no, not a, it's a worker, a UPW worker.
okay.
Yeah,
Okay, so 4 total, that includes the 2 existing, right?
correct.
Okay, thank you.
Okay, we'll follow up and you'll get that in writing.
Chair.
Thank you.
Thank you.
Okay, Zach,
Yeah, thank you, Chair. Yes, Rodney, thank you. For that positions that we're adding for the 200 positions, is that 40 positions?
It would be 41 positions.
Okay.
There's
Yeah.
yeah,
Out of
Not
the
adding-
41 positions, would you be able, would you know if there's some positions for Molokai?
oh, yes, there is.
Okay.
Yes, the water people.
Would you be
Would-
able to somehow send me that information later?
Yes,
Okay, thank
will.
you.
and Zach, just for the record, we're not adding positions. We're already authorized for 200. We're
Yeah.
just seeking funding.
Yeah, I just wanted to see those vacant positions. Thank you.
Mahalo. Other commission members, questions? Okay, if not, all those in favor, say aye.
Aye.
Anyone opposed? See none, the motion carries. Thank you. You want to go into H2?
Item number H2, it is recommended that the commission approve the transfer of the entire receipts deposited in the Hawaiian Home Receipts Fund as of September 30th, 2021 to the Hawaiian Home General Loan Fund.
We have a motion to consider staff recommendation.
So moved.
Second.
Discussion? Something that occurs, quite regularly. So, okay, there are no discussion. All those in favor say aye.
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 Anyone opposed? Seeing none, that motion carries. Thank you very much, Rodney. You and
Mr.
Sharon.
Chair, can I ask Rodney a question real quick?
Sure, go ahead.
Would it, because we approved this approval of the supplemental budget, Rodney, can you email me the budget that I have hard copy? What I'd like to do is put it on our neighborhood board agenda to support the supplemental budget for 2023.
Yes, I will. Thank you.
Thank you, Mr. Chair.
Thank you, Rodney. Thank you.
Thank you, Rodney.
Okay, thank you.
Thank you. Returning to the carryover agenda from yesterday, item C1. I want to thank staff for hanging in there and being prepared today to go over the carryover budget.
Aloha Commissioners, Lehua Kinilau Kano, Legislative Analyst. The motion for consideration is that the Hawaiian Homes Commission approve the legislative proposals to be recommended for inclusion in the administration's legislative package for the 2022 regular session.
We have a motion to consider staff recommendation.
So moved.
Dennis and Randy.
Second.
Mahalo.
So aloha Commissioners, a draft was prepared last month. This month is the proposals are included in the packet for your consideration. The recommendation from staff is to submit 10 legislative proposals as opposed to the 12 that we had recommended last month. After talking with subject matter experts, specifically those who work in the water area, the recommendation was to just focus on the bill that's pending in the legislature now, Senate Bill 1122, because that bill moved through the Senate and we just need to move that bill through the House. Besides that, again, there are another 10 proposals, all of which were prepared last month. I just want to highlight a couple of things because I know there was conversation around those issues. Proposal number 10 on interim rules. I know that there was support for that vehicle as possibly a way to move rules quicker to address some of the crime issues that are being brought forward. The other vehicle potentially is proposal 11. I did redraft the proposal and I did send it to Blossom. She, based on her communication with me, she was okay with the proposal. Just to explain the differences between the two. The proposal she had prepared that was included in the draft package last month would have amended the Hawaiian Homes Commission Act, but it was modeling HRS Chapter 199. What I basically did is I modeled HRS Chapter 199, but I put it in the HRS and not in the Hawaiian Homes Commission Act. So it's not making an amendment to the Hawaiian Homes Commission Act. But there's some fundamental differences between Chapter 199 and the proposal that you folks see. First of all, the proposal in the package would have the compliance and enforcement program on Hawaiian homeland set up under the department and not the Hawaiian Homes Commission. Again, my main reason for doing that is because we're amending HRS and not the Hawaiian Homes Commission Act. Secondly, HRS 199 would delegate authority from the Board of Land and Natural Resources. This bill does not delegate any authority, again, because I don't think we can do that outside of the Hawaiian Homes Commission Act. In addition, Section 199 had a section for failure to obey a summons that you would be subject to fine or imprisonment. I removed that section under this legislation, again, just for failure to appear it seemed a little onerous. I think in the HRS 199 section, it was usually because, the people were either taking historical objects or maybe burial items or maybe items that they weren't supposed to take and were caught with those items. In our situation, we're not trying to take those items. I think it's the criminal activities that are going on or illegal activities. And so just documenting that. So for failing to appear, it seemed again onerous to require fine or imprisonment. And then also HRS 199 gave the authority to search and seize property. In this proposal, it's only search, not seizure. And then I did add a section about alternative dispute resolution in the bill. So again, this is just for discussion. It still needs to go see what you folks are comfortable with. And then it still needs review by the Attorney General's office. I'm sure they'll be weighing in. But I just wanted to alert you about the differences between the proposal from last time, which was mainly amending the Hawaiian Homes Commission Act modeling Chapter 199, and then this proposal, which is in the HRS. And then finally, we did include a proposal this time. Last month, there was just a justification sheet, but this month we do have the bill on adoption. We've met internally with Homestead Services Division, and so far we feel the language would accomplish the result of having the person who's adopted either use either or both their adopted relationship as well as their natural relationship or their biological relationship. So those are the main, I think, highlights from differences between last month and this month.
Okay, thank you, Lehua. Randy?
Thank you, Chair. Thank you, Lehua, for informing us on the changes. I appreciate that. On the section failure to appear as a result of a summons issue. So that an example of a summons to appear in court would be the equivalent to issuing a citation. Is that correct?
The way the statute reads in 199, for failing to appear, you would be subject to a petty misdemeanor, which could be resulting in a fine or imprisonment just for failing to appear. That's the way it read in 199. If you think that we can add it in and just have a simple citation, we can put the language back in about failure to appear and have it just be a citation, if that would be your preference. But the way it read before on 199 reads it as petty misdemeanor subject to fine or imprisonment.
Okay, yeah, so I don't disagree. That does feel a little onerous. I'm trying to contextualize it. When we talk about a summons to appear, like if a citation is issued for a criminal violation that doesn't warrant an arrest, so it's a misdemeanor, and then that person has to appear in court, not necessarily for taking artifacts, things of that nature, but for engaging in some criminal activity that rises to the level of a misdemeanor or petty misdemeanor, they get a citation. And if they fail to appear, typically it's the judge that will issue a bench warrant. It's under the judge's discretion. So I think that still has value for if we're trying to address criminal behavior at all levels, all the way up to a felony. So anyway, that's my thought.
So as I understand it, the way we have this modeled is that someone would be violating like a lease provision, or there would be something that they're doing that would require some kind of compliance and enforcement. And so to your point, yes, a citation would issue. And then at that point, if the part that I took out is the failure to appear, because you're right, failure to appear means now they have a misdemeanor, petty misdemeanor. Now they get subject to a fine or imprisonment, and then possibly, like you explained, subject to a bench warrant issuing for arrest for a violation of their lease potentially. And we didn't know if that was the direction we wanted to go at this point, if the citation should be sufficient, and then we use other means like contested case hearing and lease cancellation rather than through the criminal justice system.
Okay, so I know I totally understand what you're saying. But I guess in my thought process, when I'm listening to what our beneficiaries are describing, and some of it are very severe criminal activities, I guess what I anticipate, what part of in forming this enforcement and compliance division, I think part of the tools that have to be on the belt is the ability to enforce criminal violations on behalf of the department in order to better serve the concerns of the beneficiaries, where action can be taken immediately rather than rely on other law enforcement agencies. So I'm just hoping that that's built into what we're trying to construct.
So Randy, is what you're thinking the power to arrest included?
That's what I'm thinking, you know, full
Right.
police powers. And that's because, you know, when I think Auntie Homie was testifying, some people are in fear of their lives. And we just don't have the capability to respond to life-threatening situations in a timely fashion. And so that's what I would like to see, that the department have that tool to respond to those situations, because we all hear it. You know, on Maui, you know, similar to what somebody else had said, their fear is that as a result of no response, the fear is beneficiaries will take matters into their own hands. And, you know, we have had situations where a beneficiary had to go to a house and say, put away the rifle. So you know, that's what I'm trying to address here.
So the bill does allow for police powers. That is in the bill. It's in section 4 of the bill on page 6.
Okay.
What I'm saying I took out was the summons or citation is in the bill. That's in section 5 on page 8. What I took out was once the citation is issued, and then if they fail to appear, then that failure to appear would be grounds for being determined to be a petty misdemeanor, subject to fine or imprisonment. I took out that portion, but the police powers, the citation, that's still in the proposed bill.
Okay, well, thank you. Well, I think I'm okay with that for now. I guess ultimately, if somebody fails to appear as a result of a summons being issued, it will be within the purview of the judge to decide if a bench warrant should be issued. So I fully expect that will continue to occur. So I'm good with that. Thank you.
Okay, thank you, Randy. David?
Thank you, Chair. So Lehua, what do we expect the result to be if we have these officers that have enforcement power and they go and cite someone and then the person doesn't appear? What is the result of that?
I'm thinking the result, because this is HRS right now, you guys have at least established a track record so that if they come for contested case hearing, because again, do we want to for failure? I don't know what, I mean, it's basically compliance and enforcement of the Hawaiian Homes Commission Act. Could be a number of things, could be very minor infractions, and it could be real. I get your point, could be real on the other end of the spectrum, but because the spectrum is so broad, I'm nervous unless we put back in there the failure to appear only for certain types, like the illegal ones, for example, and then try to clarify the way chapter 199 had was just any failure to appear for any of it would be subject to petty misdemeanor.
Right. So what I don't want to do is I don't want to tie the judge's hand, who is going to look at this and say, well, you know, under this statute, there is no remedy. There's only a citation, and there's no remedy for you not showing up. Right. So, and I don't necessarily have a problem if we have gradients of, you know, of things that are wrongdoing. If it's a, you know, their, I don't know, failure to pay their water or stop their water leak or whatever, you know, that part I'm not concerned about. The part I'm concerned about is what we've been hearing, which is the threats of bodily harm. And of course, we always have the police, right? But what we heard yesterday is the police, because they have these 2 TROs, they're not doing anything. So people have to walk around in fear. And we've heard, I think Randy had said before, somebody in his neighborhood, right? They were putting signs up that, you know, we take care of this with the, you know, a 44 Magnum or something, you know what I mean? Just like intimidating types of things. So my concern is we don't tie the judge's hands, that the judge.
Would your recommendation, David, be to leave it in there? Because then it would give the judge not just the opportunity to issue a bench warrant, but actually to make a judgment on the failure to show.
Right. So if they don't show up, there is a consequence to that the judge can issue. And it still would be within his discretion, right? So the court is going to look at it and say, if this is something that's minor, you know, if somebody didn't show up, they'll issue a bench warrant, $50. But if it's something serious, you know, they're going to want to get that person out of
So
the
shall I
homestead.
put it back in, but rather than having it be a petty misdemeanor or subject to those, you know, imprisonment or a fine, that we leave it fully in the discretion of the judge?
I mean, that might make more sense, right? Because then we're not calling that out. It's going to depend on how serious it is as far as the judge is concerned.
Okay.
So, I just want to have whatever potential options we have to be able to use them, especially on people that are bad actors. Okay, thank you.
And let me just say one thing about this proposal that I just want to let everyone know. My biggest concern about this bill isn't even about what's in it. It's that once it's in the legislative process, I think there are going to be those, for example, Mauna Kea, that may view this as we're doing this in response to Mauna Kea. So I think a lot of this is going to be on messaging, that this really came at the request of beneficiaries because of the criminal activity that's taking place. So things like Pastor Cardenas's testimony and others that we've received, I think we have to really highlight that, because I'm letting you know, I'm suspecting that's going to be our bigger problem, is that when people see it, they're automatically going to assume this is in response to Mauna Kea and we wanting to enforce not having people there. So I'm just letting you know on the messaging side, that's going to be a critical piece with this proposal as well.
Okay, thank you. Mike, then Russell, and then back to Randy.
I'd like to ask my question later. I think Randy's want to continue this discussion, or maybe Russell.
Okay, so Russell and then Randy.
I want to hear Randy's points too, but what I was meaning to add was I agree with the comments. I think that I don't believe that going forward we would use or we're allowed to use officers with police powers to enforce lease provisions. That's a civil matter, and we still have to jump through all the hoops that you would in a matter. What we're talking about are criminal matters, and in those matters, I think you have to give somebody, an officer, the full ability to do things, including, you know, I heard about search and seizure, and we limited that just to search, but without seizure, I mean, I hope Randy can clear this up, but, you know, I'm thinking about drug house and gambling establishments that are opened up. If we go in and search and we find firearms, we find illegal substances, we find gaming equipment, I would think that we have to have the ability to seize, to build the case that eventually goes before the judge. So I think limiting it to just search handcuffs us. It makes it empty. But on the first part, the misdemeanor and the ability to assess a fine for not showing up, without that, it's, you know, why do people show up? They just ignore the summons. But with it, I think that the mention of a petty misdemeanor, I understand that's the lowest level. So you're telling the judge, hey, don't bump it up to a huge punitive crime. It's a petty misdemeanor not to show up. You can start there. So by taking it out, I think we're kind of opposite effect of what we think we're accomplishing, because the judge already has that discretion. I think the mention of petty misdemeanor just tells him how we intend him to exercise that, or him or her, how we intend the judge to exercise discretion.
So just to respond before I go to Commissioner Awol, I think the fine line I'm trying to walk is that I'm amending HRS and not the Hawaiian Homes Commission Act. We start seizing things and stuff on Hawaiian homelands. I'm not clear if we can do that outside of the Hawaiian Homes Commission Act. And that's why I'm trying to tread that line. I feel like it's a very thin line when we start going into needing to be in the amending the Hawaiian Homes Commission Act versus HRS. What I would hope is that our compliance officers would actually work with HPD, and so that we would, if we need those full seizure, for example, we have HPD with us potentially and not always going alone. But that's the thin line I'm walking, and we'll see with the AGs. They may bounce it back and say, no, I have to amend the Hawaiian Homes Commission Act. But that's part of the issue that I'm trying to be mindful of.
Yeah, Leila, real quick to answer your one comment. I know that we currently have problems getting HPD to show up and to enforce, and I know that's more an interpretation than an actual restriction on their part or a prohibition. But I would think that if we went through the process of creating our own force with policing powers, HPD is going to further throw up their hands and say, hey, that's your guys' job. That's not our job. We're going to get less cooperation than more, I would think so. And just because of lack of resources and who's paying for those services kind of argument. But that's just my thought. And yeah, I'm done on the issue. Thank you.
Thank you, Russell. Officers with enforcement powers can be creative in terms of how they collect things for evidence. So if there's a bunch of gaming machines in a house at the time of the search, they could be taken into possession as evidence and held until adjudication. So that's another tool without actually seizing something. I've seen it done many times, and perhaps Randy can talk about that. And Randy, if you wouldn't mind addressing the issue of potentially other law enforcement agencies not stepping forward because we essentially have some officers. I know that you expressed to me that having our own officers with sort of skin in the game is something that you believe that would be beneficial to other state law enforcement agencies. So the two of them deferred to you. Would you please carry on the conversation?
Yes, I think Russell does bring up a legitimate point that if they're having trouble showing up now, that may be become more of a problem because they say you guys have a law enforcement organization that's your kuleana. The flip side to that, and my experience has also been, they will show up if they now understand your purpose and your role as a professional organization that is now wanting to form partnerships. I think that brings more value to the table. It encourages this professional relationship, the partnerships that can be formed, and it does require work. It does require outreach. I think over time, you will get a much better response from the police department than you currently are having. Because when we have no resources, these agencies feel like they're babysitting the department because they bring nothing of value to the table to help them with their caseload. So that's just part of the reality. And when you have a professional organization embedded within the department that also provides opportunities for the law enforcement representatives to meet with prosecutors, to speak to them about bench warrants, about strategies, to is this something that we can bring before the courts? All of those relationships start to develop, start to evolve, and it I believe will strengthen the department and will make our community safer as a result.
Okay, thank you, Randy. I'll go back to Mike and or Russell, now that you've heard Randy. Mike?
Yeah, so I'm got a clarification question on different item on the adoption one for Lewa. So what I wanted to ask is what we have here, this proposal is for adoption. So we're talking legal adoption, not like anai or anything like that, right? Can you clarify
Yes.
that?
Yes, legal adoption, yes.
Okay, so I have another follow-up clarification. So if a child is less than 50% Hawaiian blood is adopted by parents who combined would be 50%, would that adopted child then be considered to be qualified?
So if you're saying that qualified to succeed to a lease, is that what you're referring to?
Or qualified to be on the wait list because the adoptive child is not 50%, but the parents combined would be.
So as I understand it, the way the department operates now is you have to qualify based on your blood quantum, whatever it is, that relationship. So if your adopted parents would make you 50%, that's not acceptable. It's whatever your actual blood quantum is. So if they're less than 50%, but at least 25%, they still could succeed, but they need to have that relationship, right? It needs to be either your spouse, child, or grandchild, or brother or sister. And so sometimes people use that mechanism of adopting someone. So now they have that legal relationship, but the blood quantum was already established, under their natural or birth relationship. Does that make sense?
So the blood quantum is tied to the biological relationship, not the adoptive relationship.
Yes.
Right, yeah, it makes sense. That's the clarification I was asking for. Thank you.
Mahalo. I want to give Russell another chance since he deferred to Randy before I go to Dennis and Randy.
Thank you, Chair. I don't have further comment or follow-up.
Okay, thank you. Dennis, then Randy.
Lehua, excuse me, let's see if I'm muted. I'm not muted. Okay. Lehua, in the actual bill, you said that it shows somewhere where they have police powers. Can you point that out to me? I'm trying to read through it. I don't see that.
So proposal number 11.
Yes.
And it is page number. Starts on page 6.
And it says somewhere in here that it's,
So
I
it
don't-
basically says the Department of Hawaiian Homeland shall have police powers and may appoint and commission enforcement officers within the compliance and enforcement program on Hawaiian homelands. Persons appointed and commissioned under this section shall have and may exercise all of the powers and authority of a police officer, including the power of arrest. And in addition to enforcing the Hawaiian Homes Commission Act 1920 as amended and rules adopted thereunder, may enforce all other state laws and rules and county ordinances within Hawaiian homelands, provided that such powers shall remain in force and effect only while in actual performance of their duties, which shall include off-duty employment when such employment is for other state departments or agencies.
Okay,
That's,
thank you for pointing that out. I just had a problem trying to find it. Thank you.
Okay, no worries.
All right, thank you, Dennis. Back to Randy.
Yeah, so, thank you, Chair. So, sorry, I'm a little rusty on chapter 199, but I have it in front of me now.
Mhm.
So 2 points. The first one made by David is part of what I'm struggling with, because I'm trying to be sensitive to what you're trying to navigate through in order to keep it statutory versus having to amend the act. So I get that. But I guess this is more of a question, because to David's point, so when we issue a summons, and if we remove that section that's currently under consideration for removal, does that remove the judge's discretion to even issue a bench warrant? And that I don't know.
So that's why so 199.6, failure to obey a summons is what I took out of our draft, because this is what I was picturing in my head, and I may be way off base, is that if you give them a citation for whatever they've done, right? And then if they fail to appear, now you're laying a track record for this body to make its decisions through contested case if you're going to move towards lease cancellation, rather than going into the criminal justice system. That's what I was sort of trying to avoid. However, that being said, if that is the preference, and as Commissioner Ka'apu said, I can put that language back in, failure to appear, and then leave it to the discretion of the judge would be the other way. So I could actually put it back in. So that whole failure to obey a summons, it's not in our proposal. So that's the one part of 199 I did not put in our proposal. However, if it's the pleasure of this body to put it in and give the judge the discretion, I can put the language back in, but don't have it be a petty misdemeanor, subject to just leave it fully on the judge to render whatever he would like to do for failure, which I would think is pretty much only, well, he could fine too, right? Just issue a fine, a small fine, all the way up to imprisonment. So we could put it back and give it fully, and don't put any, there's no petty misdemeanor. It's just, we leave it to the judge at the judge's discretion, if that's what the preference is for this body.
But my concern is, by not putting the language into our bill as stipulated in statute, I don't want to create a situation, as David points out, ties the judge's hands, because the judge will go to the language contained in the statute to issue the bench warrant, and it's not for him to decide if it's a petty misdemeanor or misdemeanor. That's determined by statute. And that's my concern. If we start removing things, I just don't want to muddy up the water. So there's that. The second thing, when we begin talking about an entity that has full police powers, I don't think it's wise for us to try to remove certain things from a police agency that is already embedded in statute, because, as Russell points out, the administrative process is separate from the criminal process. So when you're engaging in a criminal process, that whole process develops separately from the administrative process. So if a citation is issued, for example, so let me go to DOCARE, DLNR. We have a criminal process, we have an administrative process that goes before the board. Now, in what is necessary, and I know over time, the department will have to do this. They're going to have to develop rules for I mean, some criminal penalties, some criminal violations that are already embedded in law and statute ordinance. Our staff can go to that. But over time, the department will likely want to develop rules for the department that looks at more specific issues that would constitute a violation that they can go to issue citations. Now for DOCARE, for example, taking lobster without eggs, that's a rule that's not in statute, but statute authorizes the department to create rules. So if somebody takes lobsters, the advantage of issuing a citation is you start to mitigate quickly. You don't have to wait for it to go before the land board. And so it goes before the courts and it gets addressed fairly quickly. And so the value in creating two pathways is that criminal gets resolved quicker, typically, than bringing it before the commission for contested case hearings. What it also does, it alleviates the staff from having to prepare contested case hearings for what I anticipate will result in many cases that could potentially come before the commission. So I think keeping the two separate is important. And if we acknowledge the value of keeping both separate, then we don't want to remove statutory language that will help to make the criminal process efficient and effective. So when to Russell's point about having the ability to search but not seize, I just did a quick read. I'm trying to do a quick read on the statute. I think that's 199-7. So it states in part, shall have the authority to conduct searches on probable cause as provided by law and to seize any equipment, article, etc., including archaeological artifacts, whatever, as a condition of probable cause leading that officer to believe the property being seized constitutes fruits of the crime. So if we are removing the seizure part, I would agree with Russell that ties the officer's hands. Because if he cannot seize, if certain language is removed and he can't seize at all, I'm concerned that he can come across evidence that that person cannot even seize as property for the case.
Randy, could the officer hold as evidence these items?
No, they can hold as evidence, and this is my fault, my bad. You know, I didn't deep enough dive into the language that's being removed. I guess all I'm asking the department to consider is that if we're going to remove any language that takes away the authority of an officer to seize property, even as evidence. That would not be good. Now asset forfeiture, that's kind of a different animal, but I don't know yet. It's not clear to me yet what seizure authority we are removing from the language.
So the bill as proposed, I took all the seizure out because in my head, this is the part I'm still trying to figure out, and I am going to need the AGs. Can we seize things on Hawaiian homelands outside of the Hawaiian Homes Commission Act? So now I feel like we're starting to tread into the Hawaiian Homes Commission Act that you got to amend. Or to your point, we go the other route, which is what Auntie Home was suggesting. We do this all through rules. We don't do it through HRS statute. And so that's why there's the other bill that allows for interim rules. And then you do it all through admin rules rather than doing it through statute. But I don't know if you can do police. I don't think we can do police powers through admin rules. And so that's why it's like kind of in a way I'm thinking maybe we choose, like maybe we just focus on the police powers and certain components, and then we can do the other parts potentially in the rules. I don't know if that's muddying the waters more, but that's my concern, is that how much are we going to give in statute, not in the act, to allow these things to go on Hawaiian homelands?
So if I could make a suggestion, I do think we would benefit from some advice from our attorney in executive session with regards to this discussion. So
yeah, I would agree. And so Lehu, look, again, I want to emphasize, I appreciate the situation you are in. I guess to summarize, well, there's a couple of things. I would agree. I don't think you can delegate police powers in a rule. I think it has to be statutory. And then what's left after that is what can we delegate to the rule to complete the package? And typically, in my experience with DLNR, the rule tends to identify violations that the department wants to identify as criminal violations. So I guess that's my caution on the search, the seizure. In order for that department to be effective, I would not want to see that occur if it ties their hands. And then as far as obeying a penal summons, I would not like to, as David points out, I would not like to tie the hands of the judges either. And I'll just leave it with that. And I can see this is going to require more discussion, but thank you, appreciate it.
okay, thank you, Randy. And I'll ask the other commissioners with their hands up if they wouldn't mind holding their questions, because this is like fresh in everybody's minds now, the issues. I would ask for a motion to go into the executive session to convene the session pursuant to section 92-5, subsection A, subsection 4, Hawaii Revised Statutes, to consult with its attorney on questions and issues pertaining to the commission's powers, duties, privileges, immunities, and liabilities. Can I have?
I have a discussion.
Sure, go ahead.
Are you requesting to go into executive session now?
Yes.
Why
Can we
can't
just do it as part of, yeah,
We do it part as the other agenda. Let's finish what we go through.
Hang
and
on,
then
my concern.
Can I just
I-
finish? Can I
No.
just finish?
No, let me finish first, real
But
quickly.
I asking the question. You're
The con-
interrupting me.
I'm
I have a
explaining,
question.
let me explain why.
Oh,
the
never mind.
motion-
You always have to
We're gonna lose the attorney with the most experience if we wait for the regular session. That's why I'm suggesting that we do it now. That's all. So. we
Thank
have
you
a
for the
motion.
interruption, but we're in a discussion right now as a motion. And all I wanted to suggest was if we can go into executive session in the afternoon like we normally do and talk about this item C1 and to move forward on the agenda and try to complete the agenda from yesterday. That was just my suggestion. It's a friendly suggestion. Thank you.
Right. My answer was, I don't want to lose the attorney with the most experience who can provide us the information that we
And
need
what
now.
attorney is,
He's-
and what attorney is
not-
that? We always have an attorney all day through our meetings, but the delay that you put us into executive session and back and forth, it delays this entire day. That's what I'm trying to say.
Yeah, well, I'm gonna ask for a vote. All those in favor of going to an executive session, please say aye.
Aye.
Aye. Is there anyone opposed? Okay, seeing none, the motion carries. Can we clear the virtual? Yes, yes. One, you gotta go out.
So Chair, you gonna take a 5-minute break or we're just gonna wait? Go right?
Why don't we take a 5-minute break and then Craig, you can prepare,
I
okay?
gotta use the restroom.
All right, no problem. I'm sure many others too. regular session and continue the discussion on this proposed bill for enforcement powers.
So thank you, commissioners. I believe I do have the direction based on our discussion. So just for clarity, what I believe I heard was that, first of all, to recap, we are going to keep the language in there about, so the part about failure to obey a summons, that language will stay in there, but we will give the judge discretion. So there's not going to be subject to a petty misdemeanor or fine or imprisonment, just allow for discretion for any failure to appear, to obey a summons. So that's what I heard. And then the search and the seizure will be in, but again, it's going to be very broad is what I'm hearing, because other parts of the statute that already address the underlying issues are covered in other parts. So this would just allow for police powers, the ability to search and seize, and to give the judge's discretion on failure to appear or obey a summons is what I understand. We walked away from the discussion. And then I believe the AGs may also help us with some language to put in there, that there could possibly be some administrative rules that might delineate beyond what's in the statute, is what I heard. So unless anyone else has anything different, that's what I believe is the direction of the draft for consideration for the commission. And then obviously it still will go through AG review and any other additional input.
Okay, Randy, you get your hands up.
Yes, so that's not what I heard. So I believe, well, I'll speak to what I had recommended, that we just leave the language as is, so that the authority for our officers to do certain things remain. I don't know if I believe it's the statute that delegates to the judge the authority upon which he can decide these matters. It's not for the department to say to the judge, we want you to use your discretion on how you deal with somebody who fails to show up to court. I think that's determined by statute. So I would not want to remove that unless the AGs has some other way to address the concern that the department is bringing up.
So just to understand, 199.6, failure to obey a summons says any person who fails to appear at the place and within the time specified in the summons of citation issued by the officers or their agents or subordinates. And then there's the other part that pertains to DLNR, shall be guilty of a petty misdemeanor, and upon conviction shall be fined not more than $500 or be in prison not more than 30 days or both. That's what the statute says right now. What I understood in our conversation with the AG, you're correct that we could leave it as is, or the other option is we give the judge's discretion, which is that we basically say failure to obey a summons will be subject to whatever decision and I'll find the language, by a court, rather than saying automatically petty misdemeanor. To your point, it could go the opposite way. They could find somebody guilty of a felony. So I get the concern. If you want to be very specific, like in the statute, if we're exactly modeling 199, that's what 199 says right now.
Well, I'm more inclined to want to be more specific than general, because you're right. It's a double-edged sword and we don't know what it could become. That said, by keeping it in the language, it will be subjected to further review by the AGs. And that's where the deeper dive will occur. Now because this is the statute that gives our officers the authority to act. And so What I don't want to do is prematurely remove certain authorities that they need in order to carry out their duties. And so even in the search and seizure 199.7, I can see where a lot of that language pertains to DLNR. So I can see a lot of areas where things can be removed. But the essence of a search, which results in the officer determining a criminal activity has occurred, I want to make sure that they can seize evidence to substantiate the case that they're going to make. And when we're talking about seizure of evidence, we're not talking about seizing a home yet. We're talking about, again, fruits of the crime. For example, we have heard people on porches with machetes, threatening occupants of the dwelling. Our officers roll up. If they need to make an arrest, the seizure as fruits of that crime would be the machetes. In complaints where firearms are being brandished, Chapter 134 would kick in. You know, it could be felon in possession of a firearm, reckless endangering. Those are what's required to initiate a case, is to seize the weapons. So these are just some examples of where search and seizure, you have to have both. So I just don't want to see one stay in place and the other removed. So anyway, that's my monologue.
So hearing what you're saying, Commissioner Wah, I think what you're saying is just lift 199, which is pretty much what I did, except for those areas I told you. But what I'm hearing you say is lift 199 and put it in our proposal, which I can do. I'll put back in exactly the language and then let the AG through that review process see. What I heard them say that's not in our language, which I'm okay with them adding, is that section about admin roles. We'll just need to add that section because that's not in DLNR statute either. So we can add that in. And the only other thing I added in that is not in 199 is about alternative dispute resolution. That's the only thing I added in apart from what's in the statute. I either took out and then that was the only thing I added in.
Okay, so that would be my preference because it can still be tweaked by our AGs. So I'd rather leave it in and then have it subjected to further scrutiny and discussion and see what pops out. So that works for me. Thank you.
Thank you, Randy. We'll go to Russell and then Dennis.
So the biggest thing I thought I heard Craig tell us is that what this officials with police power are enforcing is law, not because this act that we're reading through, you know, in section 1, it starts with authorities to ensure compliance with the Hawaiian Homes Commission Act as amended and our rules adopted thereafter. And then throughout the bill, it makes reference to enforcing the Hawaiian Homes Commission Act. I thought what I heard Craig say is, but the Hawaiian Homes Commission Act doesn't have any specific criminal type prohibitions and powers. So we have to keep that by rule. And if we wanted to do that, we'd want this reference in here. But I also heard him say we could just give them authority to enforce compliance with law.
Yeah, so actually, the language I think you're thinking about, and I can lift it off, is in section 4 of the bill on page 7. It talks about the authority of a police officer anyway to enforce the Hawaiian Homes Commission Act may enforce all other state laws and rules and county ordinances within Hawaiian homelands. I could lift that language from 4 and put it in 1 where you're reading, so that it's not just the Hawaiian Homes Commission Act, but these other state laws and rules and county ordinances. It's on page 7, lines 6 through 7. You see that language? I might just lift that and move it into section 1.
So I guess, Randy, a question for you. Do you feel we need policing officers with authority specific to violations that we define, or are addressing the concerns by just having police officers who have police powers to enforce law on Hawaiian homelands?
Yeah, well, thank you for the question. I think there's two parts to that. I think the first part, as Lehua mentioned, lifting that part and inserting it into the language where our officers will have the ability to enforce all rules, laws, ordinances, and you know, whatever broad package that comes with, because that gives them the authority to go to a variety of areas where they can clearly identify that there's a criminal activity occurring, and that they may find it in a county ordinance, they may find it in statute. And so I think if we start with that broad authority that they have the ability to do all of it, that's a good starting point. I think eventually, to your other question, is I think it would behoove the department to start thinking about being more specific about violations they would like to identify as a rulemaking package that violates the act. So for DLNR, for example, they have both. They have the authority to enforce statute, ordinances, all relevant federal, state, as well as county laws. And so that's the broad authority they have. And then for the more specific issues that are specific and unique to DLNR, they have rules for that. So I would anticipate that for Hawaiian homes, we too will want to look at rules that are specific and unique to our situation and our beneficiaries and begin developing those rules. So hope that makes sense.
Yeah.
Okay. Are you good, Russell?
Yeah, I'm good. Thank you.
Okay, let's go to Dennis.
Yeah, so, yeah, I look at this in the same light. I think we want our enforcement team to have police powers. And they currently have, and their current responsibilities are rule violations, lease violations, and so on and so forth. So their police powers cannot be limited. If we limit their police powers, it does handcuff them. So I agree that they should have police powers, and they should have the current powers are to go out and do investigations and so on and so forth. During those investigations on a rule violation or a lease violation, rule violation, they run into a bunch of drugs. They should have the ability to use their police powers and say, okay, we have another situation. So that's what I think would give us the control and also ensure that our beneficiaries are happy with the turnout, because now they're actually coming in and have the powers to do the things that normal police officers have to do. Thank you.
And I think the suggestions that Lehua has taken from both from Craig and from commissioners should provide the language that's necessary. Okay, are there any other questions? Concerns? Okay, so we have a motion on the table. Lehua has direction. All those in favor of?
Wait, I'm sorry, I forgot the motion.
The motion was that the Hawaiian Homes Commission approve the legislative proposals to be recommended for inclusion in the administration's legislative package for the 2022 regular session.
Okay, then I have another.
Yes.
Sorry, not to drag this out anymore, but on my favorite subject of gaming, I read this and I understand, what our concern was before is that we had not vetted this issue. And so I see this as an attempt to do that. but it seems to have like a predetermined outcome. And I would like to see it be more neutral. So if we're gonna be reviewing the feasibility of it, that's what we should be doing, and looking at the benefits and as well as the social harms. But this goes a little bit further because it's trying to determine the ideal factors for the siting of an integrated, so it's a predetermined decision already.
Take
Like,
that language out.
yeah, if we could leave it more neutral, then I'm fine with that, because that was what I wanted to see the last time it came before us, was that, when we look at it, so that was the first thing. So if we make it more neutral. And number two, are we asking the legislature to fund the 500,000, or is that coming out of our fund?
We are asking the
We're
legislature.
asking the legislature, section 3 is appropriated out of the general revenues of the, basically the general revenues is the state
That's
revenues.
the state. Okay, so.
But we can ask that. That doesn't mean, I hear you.
Yeah, so I just want to make sure that, if the legislature is going to give it to us, that's fine. And I think, we can ask for that. If it's coming out of our funds, then I would have to think about that more as to whether or not that's an appropriate expenditure of the beneficiaries' funds. Okay, thank you.
Yeah, Chair.
Mr. Chair, oh, sorry.
Pauline, could you hold on?
Okay.
Zachary first, then you, Pauline.
Yeah, I agree with David on his comments. So I'll go along with what David has discussed about the gaming. Thank you.
Thank you, Zach. Pauline?
Okay, Lehua, I would like you to go over each proposal. The number, just go over the number and the title that we are approving.
So the proposals are proposal HHL 0122, and that is relating to independent legal counsel. HHL 0222 relating to the Commission on Water Resource Management. HHL 0322 relating to tax exemption. HHL 0422 relating to cesspools. HHL 0822 relating, HHL 0722 relating to counties. HHL 0822 relating to historic preservation reviews. HHL 0922 relating to gaming. HHL 1022 relating to interim rules. HHL 1122 relating to the Hawaiian Homes Commission. You know what, that one I need to change. I think it's actually, the bill is actually, sorry, that is incorrect on the, but I think the actual bill says relating to compliance and enforcement. Let me just make sure. I just don't think it was updated on here. Relating to compliance and enforcement on Hawaiian homelands. HHL 1222 relating to adoption. Sorry, I just didn't update the title on the bill on this submittal, but the title on the bill is relating to compliance and enforcement on Hawaiian homelands.
That's
Okay,
sufficient.
thank you.
Okay, Patty?
Okay, thank you, Lehua, for putting this together and the discussion. But I will be supporting proposals 1, 2, 3, 4, 5, 6, 7, 8. I will not be supporting proposal 9, but support proposal 10, 11, 12 to move forward. And knowing that the legislation, we're asking the ledge to provide 500,000 for the study of gaming, I will object to that also and lobby that off. Thank you very much.
Okay, so however, the motion is to approve all of these. We're gonna need an amendment to pull those out. You want to have a separate vote on those?
I'm just not supporting proposal number 9, but I will support all the other proposals.
Okay, well, why don't
For the record.
So I guess the motion now, well, you guys have a motion. Do you want to amend it?
We have a motion.
You have a motion on the floor to support all the full amendments,
Yes, so.
but
I'm looking-
I'm not entertaining a motion For the record, I'm supporting all the other motions, but not supporting motion number 9.
You just want to state that on the record, or do you want to have a vote separately on number 9?
Yes, sir. That I will not be supporting proposal number 9. HHL 0922.
So is stating that on the record sufficient for you?
Yes, that I support proposals 1, 2, 3, 4, 5, 6, 7, 8, oppose proposal HHL 0922, and support proposals 10, 11, 12.
Okay, so can I have a well, all those in favor of the motion, say aye.
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 Anyone opposed? Seeing none, the motion carries, and on record, your opposition to number 9.
Thank you,
Yes.
Mr. Chairman.
You're welcome. Okay, thank you, Lehua. C2. Paula and crew.
Aloha Commissioners, Paula Ilaw, Acting Administrator for Contact and Awards Division. Good morning. Requesting approval, motion to approve 4 99-year leases in the subdivisions of Kakaina, Nanakuli, and Ka'ulo Kahai.
Okay, we have a motion to consider staff recommendation.
So moved. Second.
Thank you.
Mahalo.
Discussion.
I'm sorry, what item is this? Sorry.
Item C2.
C2,
You wanna continue?
C3?
No,
Oh.
C2. Any discussion that you want to share?
No, are there any questions for the awards team?
Yeah. Hi, Paula. Hi, Paula. What is Aloha, Paula? What is the Nanakuli subdivision first and second series? What is that though? And where is that?
This is a pre-owned lot that came back to us. Kyla, if you want to address that, please.
Aloha, Commissioner.
Aloha.
So this particular lot is on Haleakala Avenue,
Oh, okay.
if that helps identify the location. As for the exact series, that's just the information we were provided when we received the lot.
So it's a pre-owned home that we're offering back out.
Vacant lot for this one,
Vacant lot,
sorry.
excuse me. Thank you, Kyla.
Okay, I know which. Thank you very much.
You're welcome.
Thank you.
Any other questions?
Okay, seeing none. All those in favor of the motion, say aye.
Aye.
Aye. Anyone opposed? Seeing none, that motion carries. Now you go to C3.
Mahalo. Aloha Commissioners again, requesting a motion on C3, which is a rescission of homestead lease award and reinstatement of applications for Laiopua Villages 4 and 5 undivided interest. I do want to make a request to amend this submittal. And the amendment would be to remove the last 2 on this particular list, Akau Sono Nini and Enriquez, for the reason being that I had some questions after this was submitted. So I'm still resolving that with the partners who are handling the applications on this project. So the request, if the amendment is acceptable.
We'll seek, let's have the discussion and then we'll seek the amendment after the discussion, because there may be questions that may impact.
So you want me to continue with the rest of the 4?
Well, that's. We still need a motion. We still need a motion to consider staff recommendation. Let's do that first.
So moved.
So the recommend.
Thanks, Dennis. Okay.
Thank you. So the recommendation is to approve the rescission of 4 undivided interest residential leases as named for the following families, last names Colino, Spencer, Tina, and Wong. And then to reinstate the 4 as residential applicants on the Hawaii Island wait list according to the original date of application. Questions?
So Paula, my concern, and I think that was stated last month, was I believe that the applicants or the lessees, because they're all undivided interest lessees.
Correct.
I believe that they have the right to transfer their undivided interest to a successor. And so my concern was whether or not they were given that opportunity to do
Yes.
that. And from what I heard last month, it was more that this was just completed without going through that process. So I just wanted to make sure that all of these applicants have understand that they have the opportunity to transfer their interest, and that if they choose not to transfer their interest by signing up for this rent-to-own program, that they sign off on that, like a form. And I know, like, for example, in here, there's another one where somebody's rescinding their lease. And so there's a whole notarized form that they go through, and we have a form where they do it knowingly and they understanding, you know, the ramifications of it, because it's in the event that they pass away within the 15 years, their children have nothing, right? Even though they've made all of their payments on their lease, their children have no interest because it's just a rental. And their children may not necessarily succeed to their interest as an applicant if they have insufficient blood quantum. So I just wanted to make sure, and I had a conversation with Ryan after last month's meeting. And so I just want to make sure that that is incorporated into this, so that the beneficiaries who are opting for the rent to own, and I don't blame them for doing it, just do it knowingly and waive whatever rights that so as long as they understand what their rights are and how this affects their rights, then if they choose to take the rent to own, then that's their decision. So that's my comment. Thank you.
Thank you.
Thank you, commissioners, Commissioner Ka'apu. I appreciate the feedback in this particular project, because it's the first that we've done since the pilot program in Kapolei. So working with this particular partner, we had to navigate through some processes that didn't always line up. So to your point, I understand completely. What we've done since our last meeting in August, these particular individuals that opted in initially, we did follow up with them to ensure that they understood what they were opting into. We discussed, Moana and I called each one of them individually. And we discussed the two paths that they want to confirm that they understood the transfer was always available to them. And they concurred that they did understand that. We referred them back to the letter that we sent out in the offering, where we did disclose, and they did recognize, acknowledge that they saw that. And then we discussed the other path of a rescission and how that would change their status from undivided interest lessee to an applicant, and the trade-offs of going one path versus the other. So we did follow up with them. For those that accepted the rescission, we did follow up with a letter to confirm our conversation. It was in review and consultation with our AG to concur that we were appropriately following steps at this juncture, right? So I just wanted to assure the commission that we did take additional efforts to address some of the concerns that came up last month.
Okay, thank you. Questions from Randy first, then Russell.
Thank you, Chair. So Paula, thank you for that explanation. So,
You're welcome.
You're saying then there's a letter, part of what came up last month was, I'm gonna try to contextualize it for my benefit, probably more than for yours. So an undivided interest lease, when we approach that kind of lessee, we understand that the lessee has the right to transfer that lease to a successor, right? And why that's important is because when we ask them if they are interested in being a participant in the rent to own, they become a tenant. They're not a lessee at that point. For the next 15 years, they are tenants, right?
Correct.
And so they, in becoming a tenant, they give up a lease that they don't really have to give up, because a tenant means you're not a lessee. So you still have a right to hold on to that lease, right?
Well, per the administrative rule that Blossom identified appropriately yesterday, the rental program, which is a new rule, administrative rule that was approved, I believe, in 2019, it addresses rentals for applicants. It did not address rentals for undivided interest lessees, which was the point of transitioning them from a lessee to an applicant if they chose to opt in, so they would then be eligible for this rental program.
Okay, I'm sorry. Can you run that by me one more time? I'm sorry.
Sure, no problem. So the administrative rule that is 10-7, if I'm not mistaken, 10-7-41 is specific to rental programs for applicants. That's the short version of that rule. By offering this particular project to the UIs who were provided an opportunity to consider converting their status to an applicant, that was part of the process. So in the process, in order to qualify for this rent with option to purchase program, they had to meet a status of an applicant. And so that is the rescission process. So the rescission process is basically, coming to the commission and the beneficiary stating, I would like to rescind my lease. And by doing that, they immediately or soon thereafter, my team follows up with applications, then become an applicant.
Okay,
And thus become eligible for the rental project.
Correct.
Okay, so thank you. I understand that. So in order to become an applicant, is another pathway for them to rescind their lease is to transfer it to a successor?
There is a path to do that. They could transfer. So the process is they could transfer the UI lease and then reapply as an applicant on whatever island they choose to. So in this particular case, they could have transferred that UI lease to an eligible, let's say, family member, and then submitted an application to be on the Hawaii Island wait list. That they can do. From a process perspective and laying out the steps, the timing to do that may not meet the timing of the application process for the rental project. And so the timing to transfer is dependent upon their ability and speed to get those documents to the district office. The timing for a transfer is unknown. And so while they're doing that, we've already offered the rent with option to purchase, and we're moving along to find the qualified applicants to fill the units. So again, we're in the midst of a timing issue where by the time they transfer and then they come back and say, okay, now I want to apply for this rent with option to purchase, we may have passed that already and potentially filled the units. There may be some left over, we're not sure. But it's a timing issue that UI will encounter. So the transfer is one process, and then to apply to get back onto the list, assuming we have all of their documents because they were a lessee, I don't know what the timing of that is either. Obviously, that's with the Homestead Services Division. I hope that answers your question.
It does. So, I'm looking for assurances that the now applicant was given adequate information for them to fully understand what they were giving up. And I won't know that not having seen what some of the letters look like. So that's my issue right now, but I think I'll stop there and I'll open it up to anybody else who wants to jump in.
Thank you.
Okay, Randy, there were notices that were sent out clearly delineating the options, and we could provide copies of those
Yeah.
notices if that helps you.
We can send the mailing packet as well as orientation slides that communicated the information in terms of disclosing the opt-in and also before and after what was going to happen to the UI. So I'd be happy to send that through Leah to the commissioners.
Yeah, so for me, I would appreciate that, except that we are in decision-making now, so.
Yes.
Thank you, Randy. We'll go to Russell and then Dennis.
Hi, Paula. I wanted to ask a general question and then a specific. The general is, if I'm an applicant for a residential lease and I'm awarded and I transfer that to my child because they're 25% or more, I can turn around and go back on the list?
Yes.
And so I had heard about this. I thought there was action taken on the department's part before I got involved to stop that from happening, but that's still possible. You multiple awards with the same entitlement for the same person.
Yes, but you go to the bottom of the list.
Okay, so then my question here is in the motion, item 2, it says you're gonna rescind the UI and reinstate according to the original date of application. What does that mean?
Correct.
They go back to where they started on the list?
Correct. The rescission process and policy is just that they're giving up their undivided interest lessee. And by doing that, they go back to their original place on that application list. In this case, Hawaii Island.
So Chair, where you made the point that if you did this in a residential lease, you go back to the end, you go back to the bottom of the list. But with
Okay,
a
so
UI,
That's separate.
there's two different
Yeah.
conditions here. So in the normal situation, let's say somebody has a regular lease, not a UI. They transfer the regular lease. They go back and apply.
to the
Their
bottom of the
applica-
list.
Their application goes to the bottom of the list. The UI, the undivided interest, the paper lease, if they transfer, they're eligible to get back on the wait list, but it's their original date, was it?
Application date.
Original
yes.
application date.
And it's stated in the lease, their undivided interest.
If they transfer to their
If they rescind.
children or whomever,
I
if they
misspoke.
rescind, if they transfer, if they transfer and reapply, they go to the bottom of the list.
Yes, so two different processes,
If they
transfer
rescind,
or
they go back
rescind.
to where they were on the list.
Correct, correct.
So
Yeah.
a real life situation of this is in Kanahili behind us, right? So we've built all the houses we can in that area, but there are excess UIs that were assigned that particular area. So now those who remained and didn't take an opportunity to move to another location, but wanted to stay in Kanahili, their only opportunity now is for a re-award within Kanahili, or to go back on the wait list in hopes, go back on the wait list in hopes of being offered something in another area. It's just a function of the undivided.
Right, and then
program.
and that was unfair to the people because we didn't build product for them to eventually receive a lease. But what about all the people who are waiting on the application list? Some people went onto the UI. Were they told at that time that they could come back in the same position, or?
Yeah, it's part of their lease. Their undivided interest lease states, in the case of a rescission, they would go back to the list on their with their original application date.
I guess, and it's not the subject of this discussion. I just don't understand the logic in doing that. But like I said, that's
Yeah,
not
I'm
for
not
today's
sure I
discussion.
can.
I think that
It's-
was, the department wasn't aware of how many houses it could build on a specific parcel of land. So they issued a number of undivided interests just for that parcel. Now we're at the end of the process where we've built as many homes as we can. Some of the folks that are on the undivided interest have either deferred offerings in that area or now are at the end when there's no more houses. So in the case of, is it? We offered them when they had opportunity.
For this one,
Yeah. What kind of heating?
they had to move it.
Yeah, so as we got to the end, they were offered the ability to take their UI and move over to Ka'ula o Kaha'i, where there were additional houses being built. Many of them chose not to, they didn't want to go there. So when the last house was built, there's no more houses in Kanahili. Those who are remaining have two options. They can wait for a re-award, or they can go back on the wait list in hopes that we're going to be building in an area that they want with their original application date.
But there's still people on the applicant list for that same neighborhood that they're gonna bump.
Yes, but
Yeah.
all applicants were offered an opportunity to take an undivided interest. So they.
Yeah, so I guess people must not have understood, because who would take a UI if you could just rescind and get back your place in line? Every logic would say you do that. Why would you stay on the applicant
Well,
list?
Let me provide additional information. As an undivided interest lessee, the clear benefit is the transfer of that
Right.
lease, right? If you rescind and go back to the original application date and on that list, in the case of La'iopua, they now receive other benefits in terms of it opens up other offerings to them. So when you have a lease for a specific area, like a UI, in this case, La'iopua, your offerings are restricted to that area. So since they received the undivided interest leases in, I want to say 2005, we had one large offering at the beginning. And since then, we did one pre-owned home about 2 years ago. And then we had a 10-home blitz build with Habitat. That's it. So while we're sending out other offerings on Hawaii Island, which we have been recently, as I mentioned, Discovery Harbor or other pre-owned offers on the island, Kauai High, those on the La'iopua undivided interest list are not receiving those offerings because they have a lease that restricts them to La'iopua. So the value, in particular, the families that we spoke to affirm that they understood what they were opting into. The trade-off is now they rescind and they're an applicant on the Hawaii Island waitlist, residential waitlist. They will now receive other offerings on Hawaii Island. And we have a bunch of offerings queued up, in particular in the near future. We have offerings in Kaumana, residential in Kauai High, Waiakea, just to name a few. So if they had stayed with their UI, they will not be prone to those offerings. So there is a trade-off in terms of, as a UI, you have the transfer that applicants don't have. As an applicant, it opens up offering opportunities for you to decide whether you want to participate or not. So by these rescissions that we're talking about, the 4, should they be approved, will be a tenant in La'iopua rent with option to purchase. They can choose to stay there for the 15 years, or if there's other offerings, say they want to participate in Kaumana, they can respond through our interest form and may be eligible for that offering. It's up to them whether they want to stay or they want to take advantage of other offerings. I hope that helps. Specific to what we're talking about on this agenda.
It helps me understand the what, how the system is set up. It doesn't help me understand why. But again, I don't think the why is part of probably this discussion right now. So I'm good. Thank you for the explanation.
Welcome.
Thank you, Russell. We have David?
Oh, I thought it was Dennis. So I guess my question is, if you look at D12 from yesterday, I don't know if we still have it, but for this Lauren Manoy, there is a notice of surrender of lease. And so this is not quite the same thing.
No.
But it recites, all of the terms that Mr. Manoy went through, that it's not effective until the surrender is accepted by you, surrender is ratified by the commission. And so my concern, and maybe that's why my question to Ryan is, why don't we have a document signed by the lessee stating that this is what they intend to do? Because then we can take action on it. Right now, we're taking action on what we're being requested to do is take action on a submittal that just has people's names on it. It doesn't have the documentation. And so I guess my question for Ryan is the notice of rescission of lease, if we have that form, is that the best evidence that the commission could have in order for that signed by the people, notarized by the people, to reflect that that's their intent to do that, and then we ratify that? Or is it sufficient just to ratify based on the submittal?
I think we're talking about essentially levels of evidence that the commissioners want right now in order to make the decision, right? So my suggestion here would be if Paula folks have a copy right now, is that we can either recess or defer this matter to a later time in the meeting, and they can produce those documents in the interim, just for the satisfaction of the commissioners. And if the commissioners are not satisfied, then the matter can be deferred till next month.
Yeah, but my understanding is that we don't actually have signed documents. We have verbal letters sent by the department to the beneficiaries confirming what they're going to do, but there's no actual signature by the beneficiaries who are rescinding their undivided interest lease. And so
that's what I understand as well. That's what the department did, and then they followed up again.
So if a beneficiary 5 years down the line, one of the rent-to-own people, they die, right? And then their family says, hey, I could have succeeded to the undivided interest lease. Is it sufficient to have what we have today, which is just a submittal? Or would you want something like the surrender of lease that is noted in D12? This is on a separate matter, understood.
I think going through the hypothetical situation that you raised, then it would be better to have a signed document.
So, and I'm fine, I don't want to hold this up, but I would vote to approve it conditionally on receiving a signed document that's notarized from the people that are rescinding their leases. And then that way, the files are all in order, and then there's no question, even if it comes up in the future, there's no question that the beneficiary rescinded. They signed a document, and that's what we ratified. So
That's fair, and we can definitely, we can send a letter and ask them to get it notarized by a certain date. We are against a timing issue at this point because their units need to be completely filled by the end of October. So that's fine. We're happy to do that.
Thank you.
You're welcome.
Okay, so the motion will have to be amended to reflect it's conditional upon receipt of the signed document.
Signed rescission, yeah.
Okay, so Patty was the second, and Dennis, you were the motion, the maker of the motion. But before we ask for the amendment, Dennis, I noticed you have your hands up.
Yeah, no, I was just gonna agree. We currently do rescissions for successorship. So I think something in the form of the same type of rescission, notarized rescission should suffice. That was my only comment. But I agree with Commissioner Copper.
Okay, so Patty, and Dennis, can we get your permission to have a friendly amendment to make the decision conditional? Or Randy?
So, this is a Big Island matter, so I'm inclined to defer to our Big Island commissioners, but I'm glad we have a conditional approval on the table, but to be honest, I would be more comfortable with a deferral until I see the pala, but I'm willing, that's just a statement and a comment, but I'm willing to work with the conditional approval. Thank you.
So the amendment that I'm asking somebody to make is that it's conditioned on receiving a signed rescission from the beneficiary. Is the motioner and the second okay with that?
Yeah, I'm okay with adding that in, Mr. Chair.
Dennis?
Yes, I'm sorry. Yes, I am. I'm okay with that.
Okay, so all those in favor of the amended motion, please say aye.
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 Anyone opposed? Seeing none, the motion carries. Thank you. Okay, so we have. Okay, so that was inclusive. I just want to remind the commission what we voted on, right? So that was inclusive of the removal of the most recent two, because we're going to put them through this
Correct.
procedure now. Okay,
Correct.
I just want to make it clear for the record that that is the case. Thank you.
Correct. Thank you, commissioners.
Thank you, Paula.
Thank you, Paul.
Thank you, Moana and Kyla.
Paula.
I get a time check. It's 12 o'clock. We had scheduled to go into an executive session at about this time. Yep. Okay. So we'll take a motion to go into executive session. To this. Well, we can discuss the other matter. There's another matter before the commission. Okay. So commissioners, I request for the commission to convene in executive session pursuant to section 92-5,
So
subsection
moved.
A, subsection 4. Sorry, I got to read this into the record.
Okay.
To consult with its attorneys on questions and issues pertaining to the commission's powers, duties, privileges, immunities, and liabilities. Okay, so Patty made the motion. Do we have a second?
Second.
Okay, thank you. All those in favor say aye.
Aye.
Anyone opposed? Seeing none, motion carries. Okay, aloha, commissioners. We're back from recess. We're going to do a quick informational briefing on COVID, the impact of COVID as it relates to Native Hawaiians. I thought this was very, very important, but we do have some important decision-making items to do after. But I think it's, given the timeliness of the current pandemic, Nina, would you please begin the presentation on C5?
Yes. Aloha, Abakia Mai Kako, to you, Chairman Ayla, and to the members of the Hawaiian Homes Commission, Niniao Kauai, Special Assistant Office of the Chairman. So I just want to express my appreciation for allowing us this time. I have from the Department of Health, Dr. Josh Quinn, who has a PhD in epidemiology, and also Chantel Montangi, who is in charge of the state's DOH contact tracing system. So thank you for this opportunity to present. I also want to say I'm coming to you from sunny Makaha, where it's 90 something degrees. And I am home quarantining because over the weekend, Waina Intermediate, my 8th grade daughter Lindsay's school had another outbreak. And so I appreciate the opportunity as a state employee to telework during the quarantine period while I await our test results. So mahalo, Mr. Chairman and members of the commission. I'd like to have Josh, Dr. Quinn, begin with going over the state of Hawaii's Department of Health dashboard. He has been super helpful with his team in breaking out the numbers according to zip code, and the department did provide assistance in the addresses statewide of our beneficiaries on homestead lands, because in the last 8 weeks, there was a notice, we noticed on our COVID briefings that many people on the Leeward Coast were not indicating race, whether it was Native Hawaiian, Pacific Islander, etc. And so in order to get a handle on what we were dealing with as a department and a commission, we were able to share addresses only. So thank you, Mr. Chairman, for this opportunity. Josh, I'll let you begin. Thank you.
Great, thank you, Niniao. Will I have share screen capability to share the data?
Yes, yes, you will.
Okay.
Cedric, Leah, please assist him.
Okay,
great.
Ready?
Oh, there it is. Thank you. Yeah, so thank you for that introduction. It is great to be here, and I'm just setting up Telly, who is the real magic worker here. I'm the steward and epidemiologist that manages all of the COVID data related to the dashboards. We do lots of analysis. We've put out several reports. We recently published a peer-reviewed journal article about the importance of data disaggregation. And this is all an outgrowth of really my participation in the NHPI COVID response 3R team. So with that, I just kind of wanted to give a brief overview of what we're seeing today in the state, what we've seen historically, and particularly with the emphasis on the past couple months as we've all been experiencing this Delta surge. And then I'll hand it over at that point to Telly to share what she's been seeing on the ground and through her investigation and vaccine outreach teams. So first thing I'll mention here is the new cases reported today change from the previous day, which is 280, and that is definitely coming down. So I'll show the epidemic curve here in a moment. That's something that we're always tracking, the shape of it. Is it increasing? Is it decreasing? If I branch out here and show, kind of where we've come from March 2020, we've had, a really tiny surge back then, which that was when the pandemic was just hitting the United States. Then Hawaii's real first surge was around this time last year in the August and July of 2020. And then we had a long period of basically maintenance. the tier system, keeping things in check, keeping things in control, in addition to all the other things, activities and things that people did to maintain control. And then during this time in June, we had reached relatively high vaccination rates, and everyone was feeling quite comfortable about reopening. And then the Delta variant emerged, and that first originated in the country of India in the midst of very, very low or unavailable vaccines months ago, and then began to spread throughout the world. And because of its highly infectious nature, and even though we had relatively high vaccine rates, there are still hundreds of thousands of people. As of today, we know of at least 150,000 we estimate that are eligible for vaccination and have not received the vaccine. So that's even something like 500 cases in a day, or averaging 897 per day over a 7-day period. That's still small numbers compared to the large population of the state. So, but thankfully we are seeing that epidemic curve has been trending down, and I'll describe some of the characteristics of why that is happening. I do want to show this useful map that Yao mentioned. So under maps, the value, the two views I tend to look at the most are the cases per 100,000 in the past 14 days. And that allows us to compare zip code to zip code. And it makes up for the fact that zip codes are different sizes. So it divides the number of cases by the population density so that zip codes are comparable to one another. So I'll zoom in here for a moment on Oahu. And this is basically a picture of the current last 14 days disease activity on the island of Oahu. And so we can see the darker areas representing the areas with more cases diagnosed, and the lighter areas representing fewer cases. And I know there are interests in understanding even more detailed information down to the neighborhood, even street level, for various reasons. Part of it is the data availability, and the other part is the identifiability and privacy. We do not provide more granular information than this, but we think that zip code hopefully will be really helpful to inform community members about their risk and what's going on, in their area, because we know even COVID does not respect these zip code boundaries. And so we want to be data driven, but also not rely too heavily on the data, because the data has a limit in what it can tell us. I'll reflect this over to the vaccination data. So this is a second dashboard. We can see on the main view here that we have reached a vaccination rate of about 66.6 of the state's total population have completed their vaccine series. That's the result of nearly 2 million doses administered in less than 1 year period, and 75% of the state's population have initiated their vaccination series. If we switch over to the eligible 12 and older population, and we do expect the 5 to 11-year-old population to become eligible sometime in the next 1 to 2 months, but currently only those over 12 are eligible. So that gives us an 88% initiation rate for those who are eligible, which means that additional 12.1% or 146,544 individuals are eligible for the vaccine, but still remain unvaccinated. And we can look at our zip code map to understand where those folks are more likely to be. So we take the population and subtract out or divide the number of people in each zip code who have been vaccinated by the population of that zip code, and we can identify the areas with the lowest vaccination rates in the state. So really focusing on these areas that are under 45%, and there's several in Honolulu County, in Oahu, and then several as well on the Big Island meeting that criteria. And then the other islands tend to be a little bit more vaccinated than Honolulu and Hawaii counties. In terms of race ethnicity, we do have some limitations, as Ninial mentioned, but the way we're tracking this information is to identify disparities when comparing the vaccine recipients here in teal to the population share. And while in our case data, we do disaggregate Native Hawaiians from Pacific Islanders, because the vaccination rollout has depended very heavily on federal reporting tools, those tend to default back to the minimum federal reporting standards. So we do have some limited data that show that in addition to the disparities observed, or this equity gap when it comes to vaccine distribution, Native Hawaiian NHPI collectively representing 19% of people who have received the vaccine compared to the 25% of the population. So that is representing a vaccination uptake disparity. And then in the smaller data subset, we see that among NHPI, Native Hawaiians are 84% of the NHPI population, but are only 74% of NHPI vaccine recipients. So indicating there between the maps and the available race data that we have, believe that Native Hawaiians are vaccinated at lower rates. And then the last thing I'll mention here is the trends in data over time. So looking at cases diagnosed over time by group, I'll highlight Native Hawaiians. It was around mid-June that Native Hawaiians became the group with the most cumulative diagnoses since the beginning of the pandemic. And then during the Delta surge, I'll show over here. With this button, this filter, it brings it down to just the window of time from during which the Delta surge has been occurring. So since June 27th, we've had 21,774 cases diagnosed in the state. 30% of those identify as Native Hawaiian, and we do use the definition of Native Hawaiian listed among any of the person's multiracial identities. So Native Hawaiian 30% and 21% would be what we would expect in the population using that definition. So this is where we've seen the disparity compared to the early period. I'll go back to, kind of the first year of the pandemic before a vaccine was available. Native Hawaiians were 19% of those first 15,000 COVID diagnoses compared to 21% of the population. So they were underrepresented among COVID infections. And then now fast forwarding to this most recent period where we do see higher detection rates. And I will pause for any questions and then hand it off to Telly.
Commissioners, any questions? And you can find this tool online, correct?
Let me drop the link in the chat. But yeah,
Awesome.
This is all our available data. I like being able to share it and walk through it because the interactivity is, there's a lot of kind of hidden features here that if you explore, you can take advantage of.
Okay, thank you.
I had, Mr. Chair, just a comment.
Go ahead, Patty.
Oh, thank you. Thank you. Can you hear me? Thank you, Mr. Chair. Thank you, Dr. Quinn and Neil for bringing this to our attention. Only because I have been one of the organizations in the Waianae Coast and live in Nanakuli to promote Malama R. Ohana COVID and testing vaccination sites in Nanakuli Center. You are correct when our numbers are being high in Waianae Coast. And so we turned around as community leaders working together and homesteaders to bring the attention on homestead property, which is Nanakuli Community Center, and it has been very positive. I need to really commend the Hawaii Pacific Health. We can't forget them. They come in with the Vax machine, not Vax machine, but Vax van, their whole staff, and excellent team to work with. Also with we can't forget our Waianae Coast Comprehensive, because they have worked diligently from the beginning to get our people either tested or vaccinated. But working with the team out there in Nanakuli, and in fact, this Saturday, we have our Malama our Ohana vaccination and COVID testing at 9 o'clock to 2 p.m. And last week we were out in Eva, and last week, Saturday, we're out at Nanakuli High School. So I think the community organization, nonprofits effort going out there really works, doctor, because they see us, they trust us, they don't trust the state. I'm gonna be very honest. And so when they see people like who live in the community and promote this and trying to help that, they feel comfortable, our kupunas, that we can talk to Malama. And we also bribe them with lunches and other certificates. But I appreciate these numbers and educating us, because I'm for one chose to be vaccinated, and social media can be very mean, when we're on social media, but everybody has their choice. And some of our sites, we have been, we have had protesters, but that's fine. We still continue Malama our Ohana with a positive way and try to see what we can do at working with the Department of Health in our state. Thank you very much, Doctor, and your team, Department of Health, and thank you, Mr. Chair, for the opportunity.
Thank you. Mike?
Thanks, Chair. Thank you, Dr. Quint. Very informative information. Maybe something a little different. I was just curious, well, what's the state's plan with like the booster shots? Is that going to be readily available, or what's the latest on that?
Yeah, a little bit outside of what I was planning to speak to, but it's an important question. It's very, in the awareness right now, and we are definitely focused on making sure that everyone who's eligible for a booster can have easy access to that. So we'll be following the recommendations and as they become available. So people who are eligible for an additional shot because they meet eligibility criteria on immunocompromised conditions have already begun receiving those. And we're quite confident in the rollout ability just because we saw the really robust demand. We know that it's been difficult to get that final mile, that last segment of the population who are hesitant for various reasons, that there's a whole other group who are the early adopters, and those people are going to be eligible for a booster first because it's been the most time since their second shot. And so that's about all I can say to that topic, but we're not anticipating any particular challenges in that area.
Okay, yeah. I hear you about the final mile. We're dealing with another final mile issue too. But I want to commend, what's going on. Like nowadays, I drive around town and you see signs, hey, walk in, get vaccinated. I remember when I first signed up, boy, it was a big process online and this and that. I really think that everyone involved has made a big difference in being able to do just the walk-ins. So appreciate all of that. Thank you.
Mahalo, Mike. Randy?
Yes, mahalo, doctor, for the presentation. Really important information. I'm curious. So, I can see that the Native Hawaiian population is disproportionately represented on your graphics. So I was wondering if we could see the other islands, if we could rotate through the other islands for the other island commissioners to see what their islands look like.
Yes, thank you for that. What I'm showing here right now is the percent positivity. Let me reset here. Wait, because someone had mentioned testing. So a lot of the recent efforts have focused on linking vaccination and testing. So we are seeing that percent positivity and incidence rates are correlating quite strongly. So you can toggle back and forth between that. But for disease activity in the past 14 days, this is what you would see for Hawaii Island. I'll show Maui, Nai. They're getting, can zoom out and get a little more of how that compares in context. There, Molokai there as well, and Kauai. Okay, if there's no other questions,
have-
oh, yep.
Hey, Doctor, thank you, Doctor, for your presentation. Molokai residents took the Moderna vaccine, and they have not approved the Moderna for the third booster shot. Would you know by any chance when will that happen? If so?
Yeah, so good question. I mean, these are obviously dependent on each of the manufacturers and their timelines. I am seeing really evidence of better sustained protection from the Moderna, and they think maybe that's because there's so many variables and factors to consider. But I think people who did receive the Moderna should not feel that they are somehow behind schedule. The data, I'm sure, on that will be forthcoming very soon, and that there will be an opportunity for a Moderna booster down the line, but that people who are even 6 months out of their second Moderna shot should still be quite well protected, is the data that we're seeing at the moment.
Okay, thank you, Doctor. I have another question. I don't know if you mentioned it already, but is there any other type of virus that we have to look out for? Because people were saying that there was another one in Las Vegas when people was going there. I'm not sure the name of it. So is there something else that we need to be concerned about that might be forthcoming besides the
Our
Delta
biggest,
variant?
our biggest concern is further future mutations, and there's tremendous genetic surveillance happening globally, nationally, even locally. Our state labs sequence hundreds of samples every month, carefully selected to identify and there's a whole variant surveillance program that's happening. And whereas Delta is currently the one of greatest concern because of its increased infectiousness, they are monitoring for emergence of new variants. And for instance, there's the Mu variant that has emerged, but it is not as concerning as Delta. It seems to be very rare, and it does not seem to be either more infectious or more deadly than the current circulating strains. But it's an example of they noted this new variant, and then they track it closely to identify its characteristics and properties. And so that will be ongoing. I can say that the emergence of the Delta variant was something that just had to be detected in that way, and we don't know how the virus will change over time, but we are remaining vigilant for that.
Okay, last question. I noticed that the native Hawaiian population has been hit pretty much, with the COVID. Would you know by any chance what the reason is that, what are the key factors of that? Is that their ongoing health, or is that just how it is?
Yeah, so let me pull up the time trend, because I really see it as this pandemic is not one thing. Even COVID has changed over the course of the pandemic. So I really I tend to separate it into phases, and the dynamics and risk, the characteristics that put people at risk. On one hand, it's always been a respiratory disease. So things like close contact with the more people you have close contact with, that increases your risk. But there's other factors like what really changed the game was the availability of the vaccine, because that is, prior to that, we had only what they call non-pharmaceutical interventions. This is why you kept hearing wash your hands, wear your mask, stay 6 feet apart. That was the only things that we could do to reduce and break the chain of transmission. Once someone became infected, isolation, quarantine become the next best strategies. But the availability of a vaccine which has the primary goal of preventing disease, negative outcomes from infection, that really shifted the landscape. And thankfully, the vaccine came before the Delta variant arrived. But we do see lower vaccination rates among Native Hawaiians. And so that indicates less protection in those communities on average than other communities, and therefore increased immunological susceptibility because not as many Native Hawaiians have taken advantage of the protection afforded by the vaccine. So it's a combination of vaccination rates, number one. Number two, the increased infectiousness of Delta variant. And then number three, frequency of gathering and social contacts.
Thank you, Doctor. Thank you. I humbly appreciate your service. Appreciate it very much. Thank you.
Thank you. Niniao, you want to introduce the next guest?
Mr. Chair, can I just ask one real quick, please?
Yes, go ahead.
Thank you, Mr. Chair. For Dr. Quinn, I understand that the COVID testing kits came in. Thousands of COVID testing kits came in. Is DOH are going to be the administrator to distribution of these kits in communities and to organizations that will be working with whether you live in a homestead and distributing it to the public?
I'm not very directly involved with that program. I will say that there will be some that are delivered direct to homes, and then some that are distributed through. There's a whole allotment that is going to be distributed through community organizations, and then beyond that, I'm not sure how the distribution will work. But the whole purpose of this, I think you're speaking about the home testing. The home testing is to really empower people to take control of the testing strategy and have the opportunity to kind of know their status, and to increase access at the end of the day. So, and it's a little different than before, where you had to come to a location, a lab, or a healthcare facility and have a healthcare provider administer your test. So it is, and the simple analogy is to think of it like a home pregnancy test or something like that.
So these kits, when you do your home testing, these kits cannot be used to go into a restaurant or go into a public area, correct?
Right, because it would be too easy to falsify a negative result with that methodology, since there's not a healthcare professional performing the test.
All right, thank you, Mr. Chair.
You're welcome. There's some additional.
Last thing I want to say is just a thank you to Nini Alex for the invitation and for her participation in the 3R group. Her feedback is a great representation of making sure that this group's interests are represented and voiced in that. And at the Department of Health, we're really appreciative for her partnership.
Mahalo,
Thank you.
Niniao. Thank you.
Thank you.
Okay, Niniao, you want to introduce the next guest?
Mr. Chairman, I notice Commissioner Nevis has his hand up.
Yes, Dennis. Yes, I
Yeah,
recognize Dennis.
Yeah, I just want to make a comment in regards to the booster. My wife and I took our vaccine in January, and several weeks ago, we went online with CVS and got scheduled for our booster, and we had the Moderna. So we had our booster shot about 2 weeks ago. So if anyone's would like to check, you could check online with CVS if you have them in your area, and they will schedule you for a booster.
So I got a question, Dennis. So you have to be 65 and older for that booster?
I'm not sure. I think it depends. It all depends on when you had your booster. I think they waited like 8 months, then you can get your booster shot.
And you got the Moderna booster?
Yes. Yes.
Oh, wow.
Yes. Just go online to CVS and plug in your information. Go down to other, plug in your information, and they'll schedule you.
And where did you get your shot from?
CVS.
Which may not be available everywhere, so.
Right. CVS, Longs, whatever.
So Dennis, do you need to qualify for a booster having certain conditions?
Yeah, so if I could just jump in. So in the chat is a couple of links to get all of the information that you're asking. I'm just trying to move the presentation along so that we can hear from the other guest.
Okay, good enough. Thank you.
Thank you.
Thank you, Mr. Chairman and Commissioners. Thank you, Dr. Quint, for showing everyone like how to utilize the state dashboard. I think I've learned about it and how to use it, and that's how I can like figure out responses based on Dr. Quint's presentations in our multiple weekly meetings. Next, I would like to introduce our Department of Health lead contact tracer investigator, Chantel Telly Montangi. Commissioner Teruya, I'm sure you're familiar with her because she has been working closely to help expand vaccine and testing access on the Leeward Coast. And so I'm super appreciative of you folks, as well as Rep. Stacy Eli. And also I want to acknowledge Chairman Ayla, because early on, right when the vaccine was rolling out, Queens Healthcare Systems with Dr. Akaka partnered with the department to provide on-site COVID vaccines to our Waimanalo Kupuna housing. And then the chairman did advocate with Dr. Libby Char, head of DOH, to provide vaccinations for all Native Hawaiians on homesteads before the below 55 drop. And when we did contact all of the associations, of course, like you said, Commissioner Teruya, government is always suspect, and no one did reply to Queen's offer. But we did manage to vaccinate all of state public housing on the Leeward Coast, where there's about a 45–55% Native Hawaiian population in public housing. So mahalo for bringing testing and vaccinations to the Waianae Coast, Commissioner Teruya. This Saturday, I'm happy to report my adult son and my daughter-in-law are going to get the vaccine finally, because myself and my last two youngest are vaccinated. They got vaccinated in July, and because of misinformation on social media. But in any case, I want to introduce Telly. Mahalo nui for joining us here today. Please share.
Of course. Thank you, guys. It is so good to see all of you. I see some familiar faces. Again, my name is Chantal Matangi. Everybody calls me Telly. I started out as the Native Hawaiian and Pacific Islander lead investigator for the contact tracing team. I owe my position to the Native Hawaiian organizations, OHA, DHHL, CNHA, as well as to the Pacific Island organizations, WOW, PEA, MCO, because it was really due to your lobbying as well as you advocating the Department of Health to create a team that is specific to the Native Hawaiians and Pacific Islanders. On staff, I have community members who speak the native languages, who understand the culture, and who are community members. This is very important because we understand that as we go out into the community, as we're making these calls, that our community members want to see people, they want to hear people who understand them, who look like them, and who also are a part of the community. So that was the big push. My team was created in October, so we're almost at the 1-year mark. We started out with 10 team members. I am now a team of 35 team members. Again, previously our previous leadership had said that she could not find Native Hawaiians and Pacific Islanders who were educated or who would be able to do this job. We have proven her wrong, and we continue to shine. Go ahead.
Excuse me, Tilly. Yeah, we are running short of time. So can you cover, if you don't mind, cover the challenges with contact tracing amongst Native Hawaiians? That's the major thing that we want to hear about.
No, my apologies, of course. I think our major concern that we have right now, as far as with contact tracing, is our ability to, 1, contact the community members, and 2, have their cooperation. We understand that because of a colonial legacy of mistrust, oftentimes when we call, they do not want to share this information with us. So when we call them and we say, who are the family members we don't need to tell you. We totally understand that. The issue though is if we don't have that information, we can't offer the resources necessary and we're unable to give them the proper guidance which is needed for either isolation or quarantine. The other thing that we have that we've been dealing with that luckily we've had the support of nonprofits is we have a limited amount of resources. So unfortunately, in the beginning, when our numbers were lower, we were able to offer isolation and quarantine units as well as food support. Because our numbers are so high, we've been struggling to do that. And so our nonprofit organizations have been assisting with that. Right now, those two things seem to be the biggest issue that we have as far as contact tracing, as well as misinformation. Social media, while a blessing, has also created other issues where it's very hard for us to combat the misinformation that's out there, such as this is a conspiracy, it is an infringement upon our rights, this will affect fertility. I'm sure these are all things, it's the mark of the beast. These are all things that you guys have heard. There is a very strong and robust campaign to try to address this, which is also why we have worked very hard to create collaborative partnerships with our Native Hawaiian nonprofit organizations to ensure that we're not the trusted face that needs to be seen by the Native Hawaiian community. Instead, it is their own leadership, their own community members, so that way they can share their knowledge, their wisdom, and create, again, that partnership and that road to trust. So those are our current issues that we're experiencing with the Native Hawaiian community.
Thank you so much. Questions? I'm sure commissioners are hearing the same thing.
Yeah, Kelly, just wanted to mahalo you for that presentation. It was very good, very helpful, and very informative. So thank you.
Thank you, guys.
I think we all echo that. So mahalo Tili, mahalo doctor, and mahalo Niniao for updating us.
Yes, mahalo chairman, mahalo commissioners. Thank you for this.
Thank you,
Mahalo.
Niniao. Mahalo.
Take care.
Hello, be safe.
Okay, I'm gonna ask Andrew to come up and we'll do G1 to accept the beneficiary consultation. And shortly after that, G2.
Aloha Commissioners, Andrew Choi, Acting Planning Program Manager. Item G1, the recommended motion action is that the Hawaiian Homes Commission accept this beneficiary consultation report as the official public record of beneficiary input and feedback relative to the Ahapunana Leo Inc. request to utilize Hawaiian homelands for a Hawaiian language preschool in Waimea on Hawaii Island.
May I have a motion to consider staff recommendation?
So second.
Okay. Just a quick background, Commissioners. Ahapunana Leo Inc. is seeking a new long-term license agreement with the department to continue to operate its Waimea Hawaiian language preschool at the current location on department land adjacent to the DHHL West Hawaii District Office. The site was licensed under license agreement number 488 to the school since June 1st, 2001. The previous license agreement had an initial 10-year license term expired in May 2011, then amended for an additional 10-year period, which expired in May 2021. The commission approved the month-to-month right of entry at its June 2021 meeting and directed DHHL staff to conduct a beneficiary consultation on a new long-term license for the department's beneficiary consultation policy. The beneficiary consultation meeting was conducted on July 21st, 2021, with beneficiaries that reside in the Waimea region on Hawaii Island. Because of the COVID-19 pandemic, the meeting was held on the Zoom virtual meeting platform. Approximately 12 people attended the virtual meeting, 6 self-identified as DHHL beneficiaries. Over the course of the meeting, about 25 comments were submitted by the meeting participants. In addition to the meeting held on July 21st, the department also had a 30-day comment period for beneficiaries wishing to comment on the matter who couldn't attend the meeting. We received 2 comments during that period. Just a summary of beneficiary comments. All of the beneficiaries that participated in the consultation process supported the school's request to utilize department land for the preschool. Further, beneficiaries commented that the department should reduce the rent that it is charging to the Ahapu Nanaleo Inc., as the organization provides a valuable service to the beneficiary community in Waimea. In addition, there were other specific terms and conditions that beneficiaries would like to see in the new license agreement. This included they would like to see conditions such as at least 30% of enrollees of the school must be from a beneficiary or from a beneficiary family. The license should not be for more than 10 years, and no additional land should be considered at this time until further beneficiary consultation is conducted for any proposed additional lands. And just lastly, there were no comments received in opposition of the license request.
Thank you, Andrew. Any questions for Andrew on the
Chair,
BC?
I have a question.
Yes, go ahead. Dennis.
Yes, Andrew, and again, this is not directed at departments, really directed at beneficiaries that didn't attend the meeting, but on the beneficiaries that self-identified, that were any of those beneficiaries representing an association or a group?
The president of the Waimea Hawaiian Homestead Association, Mike Hudson, participated in the meeting, and he read comments that he collected from his association members.
Okay, all right, very good, thank you.
Okay, any other questions for Andrew?
Yeah, hi, thank you, Andrew. First of all, what is the zoning in that location in Waimea?
The commission's land use designation for that particular parcel, I believe, is community use. Again, it's adjacent to the West Hawaii District Office.
Oh, okay. And so I'm comfortable with what you said, no, as what the beneficiary consultation mentioned, $900 is still reasonable, less than 1,000 and not over 10 years. I would support that project going through with that conditions as your summary stated. Thank you.
Other commissioners? Right now,
Andrew,
the motion is to accept it as written.
Andrew, I have one more question on the 30% of the enrollees in school. Do you know what percentage are beneficiaries in the school now?
I don't have that information off the top of my head, but I believe it was covered in the presentation by Ahapu Nanaleo during the meeting.
Okay.
Do you need that information before you make a decision, Dennis?
No, I'm good. I'm good.
What is the current percentage of the enrollment that are beneficiary?
I don't know what it is. I have a question, a quick
Randy?
question.
Randy?
Yeah, so I'm trying to find, so we charging them, the recommendation is, the fee is what? How much is the fee?
That's the next.
Yeah, that information is going to be covered by the land management division.
Oh, okay, I'm sorry.
Yeah,
Sorry.
just generally the feedback that we receive from beneficiaries during the consultation process is that the department should consider lowering the rent that it is currently charging to the school for several reasons. One, that the school provides a service that beneficiaries feel is essential to their rehabilitation, teaching the native Hawaiian language. And second, they question the consistency of what is being charged to Ahapu Nanaleo versus some of the other schools in the region, including Kamehameha schools, preschool, and the Hanuo Ka'aina Charter School.
Yeah, thank you, Andrew. That's why I'm asking. I see 10,800 annually, and that was my question. Are these fees comparable to what other schools are being charged? Recognizing that the service Punana Leo provides is invaluable. So anyway, wrong agenda item. So, but anyway, that was my thought process.
But a good question.
Yeah, thank you.
Chair, Chair,
Yes,
I did
Dennis.
find, I'm sorry, because we had so much paperwork, I did find in the presentation that there's approximately 33% of the student body comes from beneficiaries.
Thank you. We're gonna go to G, well, all those in favor of the motion of accepting
Aye.
the beneficiary consultation report, say aye.
Aye.
Anyone opposed? Seeing none, the motion carries. We're gonna go to G2.
Yep. Item G2, that the Hawaiian Homes Commission accept this beneficiary consultation report related to the Kamehameha Schools land use request for use of Hawaiian homelands for a preschool in Keaukaha, Hilo, Hawaii Island. Commissioners, similar to the previous agenda item.
Can I have a motion to consider staff recommendation?
So move.
Second.
Second,
Okay. Similar to the previous agenda item, Kamehameha Schools is seeking a new long-term license agreement with the department to continue to operate its Keaukaha preschool at the current location on Hawaiian homelands next to the East Hawaii District Office. The site was licensed under license agreement number 759 to Kamehameha Schools since July 1, 2011. The previous license agreement had an initial 5-year license term expired in June 30, 2016, then amended for an additional 5-year period, which expired on June 30th, 2021. The commission approved a month-to-month right of entry at its June 2021 meeting and directed staff to conduct a beneficiary consultation on a new long-term license per the beneficiary consultation policy. A meeting was held on July 28th, 2021 with the Chicho beneficiaries that reside in the Hilo area on Hawaii Island. Because of the COVID-19 pandemic, the meeting was also held on Zoom. Approximately 15 people attended the meeting. Approximately 6 people self-identified as beneficiaries, and about 5 comments were made during the meeting. One comment was made during the 30-day comment period. In summary, all of the beneficiaries that participated in the consultation process supported the Kamehameha Schools' request to utilize the department land for a preschool in Keaukaha. In addition, there was one specific comment about the need for more commercial areas within the Keaukaha community to support community economic development. However, that specific comment really wasn't related to the question at hand. There was no opposition voiced from beneficiaries during the consultation process regarding the Kamehameha Schools license request.
Any questions for Andrew? Okay, seeing none. All those in favor of accepting
Aye.
the beneficiary?
Aye.
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 Anyone opposed? Seeing none, the motion carries. Thank you, Andrew. We're gonna switch.
you,
and go back.
Andrew.
We're gonna switch and go back to the decision-making for these 2 associated items with F1 first. Donna?
Yep. Aloha and good afternoon, Commissioners. Kahana Albino, Acting Administrator, Land Management Division. Item number F1. Again, this is LMD's request to approve the issuance of license to Ahapunana Leo Incorporated out on Waimea Island of Hawaii, TMK number 364001059.
You have a motion to consider staff recommendation?
so move.
Move.
Second.
Okay.
Thank you.
So again, the recommended action and motion is that the Hawaiian Homes Commission approves the issuance of a license agreement to Ahapunana Leo Inc., a domestic nonprofit corporation, hereinafter referred to as APLI, for the right and privilege to enter and use a portion of land within the West Hawaii District Office parcel in Waimea, identified by TMK 64001-059 and delineated in Exhibit A, containing approximately 10,000 square feet in land area, together with a building approximately 3,000 square feet in size, for the purpose of operating and maintaining its Hawaiian language family-based Waimea preschool program. For your information also, I think we have participants from Ahapunana Leo. If you have any questions regarding the program, I think we have Talia Bailey, who's here to answer any questions, and or Kishan Kekina. I'm not sure if he's on too, or he might be with Talia.
Can you explain number 2, Kahana?
Yeah. I guess they might have left for the day. I mean, they've been waiting. Anyway, yeah, approval and issuance of this license shall be subject to the following, as listed, items numbers 1 through 13. Specifically, number 2, Commissioner Teria had requested. The term of the license can be extended for 1 additional 10-year period. So the initial term is for 10 years, retroactively commencing as of June 1st, 2021, and expiring effectively on May 31st, 2031. The extension is at the option of the chairman of the Hawaiian Homes Commission. Licensee must apply for the extension 6 months prior to the expiration of the term, and approval shall be subject to the chairman's review and evaluation of its financial and operation status. I know there was some question regarding the rent. Item number 3 covers the rent. In my discussion part, page 3, right in the middle of the area, says the monthly license fees as proposed is derived as follows. I have a formula there of how I derived at that number. You can see that. And those numbers were derived from my Exhibit C, directly from the County of Hawaii property tax website. You can see the number, the market land value for that subject parcel is 536,000, and that's how the calculation was spelled out, was figured out. So again, that's our proposal for $900. I know there was a question or concerns on the amount from our beneficiaries. So again, I put it back to you guys. That's a recommendation. You guys can change it or not.
Okay, Commissioner Ka'a.
Thank you. Kahana, on page 3, yep, it says the property area is 352,488 square feet.
Correct. The whole entire area is under 1 TMK, which
Oh, 1
includes
TMK,
our
our office.
Correct. So if you look at Exhibit A,
so the tax for that is the 530
total, correct.
Is on a value of 536,000.
Yes.
So I'm trying to understand, and I will tell you, I spoke to Mike Hodson on last Saturday, so he was talking to me about this. And my question is, I don't understand our methodology. I understand this, as far as this methodology, but I'm not understanding the methodology that we use when we, for example, that Kanuoka Aina got like 10 acres. It's gratis. It's a lease for 55 years, right?
Correct.
So they're paying 0. And then Mike was saying the Kamehameha Schools, which has 2 acres, which is right next door, they're paying 0. And Ahapunana Leo has 1/4 of an acre, and they're paying $900 a month. And then in our agenda on Kauai, we have a group that KKOA or whatever that is, that's like 10 acres. And we're letting them have it for free. And so I'm not understanding what's the decision-making that goes into deciding whether or not to charge somebody, and what's the criteria? Because it seems like they all kind of fall into that same, it's a cultural practice, they're providing some benefit to our beneficiaries, that sort of thing. And some people pay rent, some people don't pay rent. And I just don't understand what our criteria is. And I think, I think it's something that the commission should take up so that we don't have different outcomes for similarly situated organizations. So if we're gonna say, if you're a school, you fall into this category, the maximum rent's gonna be X or the minimum rent's gonna be X. I don't care how we come down. I don't know. I don't care how the commission comes down on that. But when you do see disparities between same types of organizations fulfilling the same mission, I just don't understand how we came down on that. So
That's a good question. I know I started when Kanu'okaina came aboard. I believe Kanu'okaina ended up being an eleemosynary type deal, where a nominal rent was considered. I'm not too familiar with how the KS deal brokered, but I just wanted to make sure that I produce some type of formula for you guys. And again, it's a recommendation.
Right.
And I'll leave the discretion at your guys' disposal as to how we charge these.
right. So if we're, so if it's by formula strictly, then we should be going back and saying, well, this is the formula for Kauai since they're going to have 10 acres. You know what I mean?
Yeah.
And that should be the charge. And I'm not saying one way or another. I just don't understand how we came up with it. And so I'd like to see some consistency going forward. So when we deal with these types of organizations, they know what they're looking at.
And in addition to that too, I believe Kanu'okaina and KS built their own facilities. So the lands were, I guess, given to them gratis, and they put in their own cash flow.
Well, I remember that this property, the property that the school is at Punana, was part of the old CCC camp, right? Which was created by after World War II, right? When they were trying to put people to work. So that building is an old, and I think we got that for free, right? We didn't invest any funds for that building. I think that was there. So, so yes, they didn't put up their building, but we didn't pay for it, right? Either.
May I suggest this, Commissioner? May I suggest, since we have the submittal before the commission today, that it's just a suggestion that we approve it as is and then come back to the commission with a recommendation on what should be more consistent application throughout different uses by eleemosynary groups or nonprofit groups for educational purposes, cultural purposes, those kinds of things. And then we can adjust the rent at that time across the board for all of them.
And I'm okay with that. The other question that's unanswered, which I was hoping the people were going to be on, is representative percentage-wise, how many of our beneficiaries are benefiting from, the Punana school. So if it's like 50%, I mean, the recommendation was like at least 30%, but if it's 50%, I think that's good information to have, because a significant number of beneficiaries are benefiting from that. So I don't have a problem as long as we're able to take a look at this again once we have the information, and once we develop a kind of a policy for this, and then we can apply the policy statewide, right?
We can go back
So-
retroactively.
Right.
Also, I think a good discussion would be not just how many beneficiary children that are being serviced by these entities, but how many other Native Hawaiian children are being serviced by these entities, right?
Correct.
Because you could have two children in a household and one be 50 and one be 49, right? So we should have that additional information also, because I think it plays into the appropriateness of approval by commission members.
Right. Okay.
Dennis?
Yes, yeah, I agree with Commissioner Copeland, his idea.
Are you okay with the course that I'm suggesting today, that we approve the submittal as proposed, and then we come up with sort of this broader view statewide for all our Elomasaneri / cultural educational groups and look at a methodology that is consistent and fair across the board. And then
Well,
retroactively go back.
I agree with the concept, yes, but when we talk about rehabilitation, I think this is very important that the testimony this morning from Mike was very, very good testimony, made very clear that this is an important part of the community. There is 33% of beneficiaries are there. I'll defer to the island commissioner, but I think it should be gratis. But come up with some standards. I agree. If you want to move forward, come up with some standards. And this standards for a lot of things, because we should have basic boilerplates for different conditions, just so that the department doesn't have to spend a lot of time going through stuff they don't need to go through if they know what direction we're going.
I'm sure LMD staff would enjoy the certainty themselves. So,
So I'll defer to the island. Thank you.
okay, any other questions?
Yeah, I did. I just
ahead,
wanted to
Barbara.
comment. Thank you, Commissioner Ka'apu, for bringing that up. It does make sense. We have a lot of ROEs that come to us, or license that come to us, that are mentioning cultural, and some of them do pay rent, some of them don't, and then it's gratis. And then they have large acreage, and it's locked up for like 10 years or more. You know, for instance, along the Waianae Coast, we have 4 Kamehameha schools, all in Department of Hawaiian Homelands. And then we have churches that are on good size acreage that pay just $200. But it's like the inconsistency of charging. And I'd like more discussion on coming up with an appropriate plan where we can go across the board and charge. Some of these organizations, they receive GIA, they receive grants, they can afford rent. They can afford some of these rents. We're always complaining that we don't have money, so we need to kind of collect some money on our properties that we loaned out. Waimea is like it's a beautiful area. I mean, Waimea Island, to get that property there, they're fortunate. Such a big acreage. So I'm comfortable with the $900 that Kahana put together, and his proposal here presented in his submittal, that at least we should charge something for it. You're talking about 10 years. And then number 2, after 10 years, they can come back and request for another 10 years. So, you know, you're hostage that land for about 20 years in that. And I do support organizations that provide cultural school activities. But then again, our question is, how many of our beneficiaries do attend? So that's another discussion, but thank you, Ka'apu, for educating me. I do agree with you. You are the commissioner from Waimea, so I trust that you're bringing it to our attention is very vital for me. So thank you. Thank you, Mr. Chair.
All right, thank you, Patty. Any comment? Okay, so you see, oh, Randy, go ahead, Randy.
Yes, so, you know, my discomfort in charging Punana Leo $900 is the disparity that appears to exist with other agencies providing similar services. So I do appreciate Commissioner Ka'apu making a request to create some kind of format that standardizes this process. Because if Kamehameha, with all of their wealth and assets, is paying nothing, and Punana Leo is paying $900 a month, that concerns me. So I just want to get that on the record. Thank you.
Okay, thank you, Randy. So we have the original motion on the floor. Randy, you have your hand back up again, or?
Oh, I'm sorry, mistake.
Okay.
Let me take them down.
I did not hear enough of a discussion to deviate from the motion at hand. So I will ask for all those in favor, say aye.
Aye.
Okay.
Aye.
It wasn't a resounding aye, so.
I'm gonna go and abstain on my vote on this. Thank you.
Okay, so one abstain, any noes? Okay, so the rest of us are ayes. Okay. Motion, now we've got a bunch of hands. Okay. Michael, and then.
Chair, so it's Mike here. I thought that there was an amendment about doing more research and coming back.
The suggestion that I had put on the table was to move forward with the current submittal as written and the current motion as written, and then we would come back at a later date with some consistent criteria by which to charge across the board groups like this in similar conditions. And at that time, we would consider reduction of rent if warranted across the board for all the entities that fall into this category of eleemosynary, educational, cultural, rehabilitative benefits, services to our beneficiaries and their children. So that's
yeah.
what.
I support that.
Yes, so do I, Chair. I agree.
Okay, thank you.
We need to
Thank you, Mike.
revisit this again. Thank
Okay,
you.
so the vote actually was taken and the motion passes with one abstention.
Yep.
Okay, so there, we're gonna go right to F2 now.
Okay, item number F2. LMD seeking the approval of issuance of license to Kamehameha Schools. Keaukaha, Island of Hawaii, TMK number 21023, 157, and 158. Similar to the previous submittal, KS is seeking a license, and the terms are listed there. We also have, I think, Neil Nihe. Is there a Neil Nihe or Shelly Kim? Okay, they might have left too.
Okay, before you proceed, can I have a motion to consider staff recommendation?
So move.
Second.
Okay. Continue.
Okay. Again, this license is for a preschool out in Hilo. For Kamehameha Schools to continue its preschool operation and related services in Keaukaha, Hawaii, consisting of 5,589 square feet, more or less, of space, together with a storage facility covering 1,304 square feet on a portion of Hawaiian homeland situated on the TMKs that I had mentioned. And you can see on Exhibit A where the location is. Oh, yeah, I'm sorry, you got Gabe Naiole too, sorry. Sorry about that, Gabe. Who's KS. If anybody has any questions regarding the operation of KS, Gabe is available.
Did you finish?
Yeah. And again, the term for this license is for 5 years, retroactively commencing as of July 1st, 2021, and expiring effectively on June 30th, 2026. Also, they have a term to extend, or an opportunity to extend one additional 5-year period at the option of the chairman of the Hawaiian Homes Commission. Number 3 item on page 1, it should have number 3. I have, I'm missing number 2. Number 2 should be that second paragraph. The term of the license can be extended for an additional 5-year period, or one additional 5-year period. Number 3, you'll see the license, how the fee was established. And on my page 3, again, the fee calculation is analyzed and broken down on page 3.
Just
Dave?
quick question.
Yep.
Kahana, I thought our rate of return was 8%.
Yeah, it is between 4% and 8%. So what I
That'll
used
be
to,
part of the discussion on the
yeah,
consistency.
exactly.
Okay. But since it's Kamehameha Schools, we should probably triple it, right?
Yeah, 24%.
Okay, Mike?
Thanks, Chair. Thank you, Kahana. This information, this is for Gabe. Aloha, Gabe. Perhaps this was in the beneficiary consultation, but what percentage of the students are from the Keaukaha community?
I don't have that right on the top of my head. I can research it and get back to you. That was part of our presentation.
Okay. Okay, I was just curious. And I know we had testimony from Uncle Pat in support of this. Do the students, Gabe, do the students have to pay to be a student?
Yes, they do.
What is the annual fee for a student to attend?
Yeah, typically when the hours are 7 to 5, it's around $3,500.
A year.
But this year, yeah. But this year, because of the COVID pandemic, we had to shorten the hours a little bit. So now it's 7:30 to 3:30, and our tuition went down to about 24, close to $2,500.
Okay. And I'm certain there's probably like financial aid opportunities for folks, yeah? And do you have any, can you also provide information on how much percentage of the students do get financial aid from Kamehameha schools?
Yep, it's somewhere in the mid 80%.
Oh, that's good.
Yeah.
Hold on, Mike. I have some information coming in from Andrew.
Regarding your question about how many students are enrolled from Keaukaha, in their presentation, Kamehameha schools reported that about 20 to 30% of the keiki enrolled live in Keaukaha.
Okay.
Thanks, Andrew.
All right. Yeah, that's all I had. Thank you.
Okay, thank you, Mike. I don't see any other hands up, and I would make the same caveat that we would consider the present submittal as is, and then as part of that review of consistency, we would come back at another point to review this. Okay. Any questions or concerns about that? All those in favor of the motion, say aye.
Aye.
Anyone opposed?
One
Seeing none,
abstention, abstain.
Okay, one abstention.
Abstain. Did you get it?
Motion carries. Thank you.
Okay, thank you.
Okay, moving things forward, F3.
Item number F3. LMD is seeking the approval of issuance of a right of entry permit to State of Hawaii, Department of Agriculture, out in Waimanalo, Island of Oahu, TMK 41011, portion of parcel number 1.
We have a motion to consider staff recommendation. So moved.
Again.
Issuance of the right of entry permit would cover the subject area identified by the TMK I mentioned, containing approximately 1,306 acres for the purpose of conducting coqui frog search, control, and eradication efforts only. The requests for access to the subject area would fall between the hours of 8 a.m. and 12 a.m. and include access permission for up to a total of 10 HDOA or Hawaii Department of Agriculture employees and or collaborators. With us, I believe we have Noni Putnam, who's a land vertebrate specialist. I'm not sure if Jonathan also is with her, Jonathan Holt. If you guys have any questions regarding this matter, you guys can ask the people that are joining us.
Okay, we have are there any questions for Kahana or the Department of Ag folks? It's kind of straightforward. They need permission to go up and eradicate invasive coqui frogs.
I have a question, Chair.
Yes.
Just general, is there a problem with coqui frogs in this locale?
There was, I guess, an introduction, I want to say about 6 months ago. And so it's the ongoing effort to find and eradicate the little rascals.
Okay, thank you.
Okay, David.
Thank you. Just a comment. Since since we have gazillions of them on the Big Island, I don't see Department of Agriculture over there asking for a ROE to exterminate these coqui frogs. And so my feeling is we should move we should move the coqui frogs to Nu'uanu, Hawaii Kai, Kahala, because then somebody will pay attention, because when it was on the Big Island and now it's just rampant everywhere, and I see no one from the Department of Agriculture out there trying to eradicate them. So perhaps we can hear from our DOA participants.
Would anybody from the Department of Ag like to take that question? What are the chances of eradicating coqui frogs on Hawaii Island?
Yeah, so can everyone hear me?
Yes.
Yes.
Yeah.
Okay, thank you. Good afternoon, Chair and members of the commission. Thank you for the opportunity to testify. My name is Jonathan Ho. I am the Inspection and Compliance Section Chief for the Plant Quarantine Branch. I'd like to start off with thanking Kahana for assisting us with getting monthly limited right of entry permits to the area in question that we've been discussing. I missed some of the questions because I was doing the live stream and trying to fix my camera. So I think, I guess if we could, repeat them and I can go ahead and answer them for you folks. I'm sorry, I was trying to fix my camera.
We had one commissioner who asked.
Go ahead, David.
I can repeat myself. I'm good at that. I had suggested that we plant the coqui frogs in Kahala and Nu'uanu and Hawaii Kai, because then we will see the Department of Agriculture's full effort in trying to rid our state of these coqui frogs. I'm from the Big Island, so we have the problem over there. And I was saying I haven't seen tens of thousands of DOA. Well, here is just 10 to go out and eradicate the coqui frogs, but I haven't seen any DOA people on the Big Island trying to eradicate that. But I understand that the politically, it would not be good for these coqui frogs to get out on Oahu to the extent that they exist on the Big Island.
Your point is well noted.
Thank you. Thank you.
So from the standpoint of the department's response on the Big Island, coqui was not a pest basically until they got to Hawaii, unfortunately. And from the standpoint of being able to eradicate it, our budget would just does not equip us for that particular act, at least on the Big Island. For every other island, we do responses to all credible coqui reports. And for example, on Oahu, we've been responding to coqui for decades. And we catch them in Kahala, we catch them, pretty much anywhere on Oahu, Kauai. Maui, depending on the location with the outside of Maliko Gulch area, so we do have active control programs. The department does fund some, I think, who is it? Kohala, to do coqui control as well on the Big Island.
We just want you in Waimea. We don't really care about the rest. We don't care about Hilo. They're a lost cause.
Yeah, I don't believe, I think it's too cold. I could be wrong.
No, the reason I'm making these comments is because
you have frogs. Okay, yeah.
Right outside his window. Yes.
Yeah. They are nasty buggers, especially at the window volumes.
Did you say Kohala or Kahala?
Kohala.
Oh, okay.
Thank you, Jonathan. Out of curiosity, the coqui frogs in Waimanalo, how do you exterminate them, or how do you treat for them?
So right now, the particular area is like it's limited to about 1.5 acres, and it's right at the base of the mountain. It's about maybe about 1,500 feet from the nearest road. It's pretty much straight uphill. It's about I think total grade is about 700 or 800 total feet in elevation to where we've caught the frogs. So normally chemical treatment is the best option. We would be basically spraying a 16% citric acid solution. It's basically the same citric acid you would see in, Coke or any kind of soda. It's food grade, and you spray it with water and 16%, and basically you spray the area until you have no frogs. The operations are normally done depending on the infestation during the day. For this particular one, because of the number of frogs, you would be doing that at night. The challenge for us is, again, the grade and the distance from the road. Normally we have gasoline powered sprayers that we would drive, and we have hoses that you can connect and you can conduct the work. Right now, we're trying to work with our engineering department to come up with a solution to do I guess, permanent, some type of, well, not permanent, but I guess some kind of like PVC type of thing that we can run, do the treatments, and then take it all down, because obviously that's conservation land. So we don't want to be leaving any of that stuff inside of that area.
It's like running pipes up and putting a sprinkler system up, right?
Yeah, wouldn't necessarily be sprinklers. We would do something a little bit more targeted. Basically, it would be a hose, and you would have like a gun that would spray, and you would target areas where the frogs are. You wouldn't want to just be spraying citric acid everywhere. It is rather costly, and to have that much mixed and pumped would create a lot more infrastructure requirements. So it's more having like a network of pipes with fittings that you can connect the hoses in, and then you drag the hoses and spray them into the areas that have the frogs.
Okay. Thank you. Mike?
Yes,
And
sir.
then Mike first, and then Zach.
Okay. Yeah, so Hannah, this is for 1 year, yeah, this agreement.
Yes.
Okay, I'm looking at the Exhibit A, and maybe for you or for Jonathan, is that little square the subject area where the studies and what all the different things are going to be performed?
No. The area that we're focusing in, like on that Exhibit A, would be kind of right where the T is, like where the T.
Oh, I see.
It's basically around that area.
Okay. Okay, yeah, we have an abundance of koki and hilo, and it doesn't bother us anymore. So in there, the only time we get bothered is when we don't hear them, and that's when it's too cold, when it's snow. Thanks.
Thank you, Mike. Zach?
Yeah, thank you, Chair. Yeah. I know it's for a 1 year right of entry request. But let's say you do eradicate all of the koki frog. This particular property, I don't know if this is Kahana that could answer my question, or Andrew. What is the terrain like for that particular property, that 1,302 acres? Is that good or?
That's a cliff face,
Okay.
basically.
Yeah, I was just curious to know what type of terrain it has. So, I mean, if it's suitable for the beneficiaries for future. No, that is my question. Okay.
Thank you.
Thank you.
There are no further questions. All those in favor say aye.
Aye.
Aye. Anyone opposed?
Reluctantly.
Jonathan, thank you for hanging in there.
Yeah, but I'm taking that question.
Thanks,
Thank you so much.
Mahalo Kahana.
Thank you very much.
Thank you.
Thank you.
F4?
Okay, item number F4. There was some discussion on this one earlier with the Kahale Po Mai Kai. I know there was some testimony yesterday. but LMD is seeking approval to issue a license to Kahale Po Maikai, Renewable, Molokai, TMK number 256002, portion of number 1, parcel number 1.
There was also a lot of discussion from commissioners about just issuing a 2-year license and then coming back and not giving the director or the chairman any extension rights. So understanding that that's the motion, I would request a motion to consider staff recommendation on just the part of the staff recommendation that talks about issuing a 2-year license.
So move.
Second.
So,
Second.
Okay, moved
Chair.
and seconded. Yes,
so we would remove the last sentence on item B.
yes.
Okay.
So Chair, are you done, Dennis?
Yes,
Okay.
go
so
ahead.
Chair,
Sorry.
So, with that said, so before the 2 years is up, are we able to come back with the commission?
Of course, that is
Revisit and for a
Yes.
longer
I would-
extent, correct?
yes, Zachary, I would definitely anticipate that the current applicant would come back before the expiration and ask for another term for the license, and hopefully there'll be
And
the plan, the settlement plan and all of that will be further along so that we can have these broader discussions.
and it's due to the fact that the Ualapue Homestead regional plan is going through the EA. So hopefully within the 2 years, they would complete the EA, and then we can revisit the request for an extension. Is that
Yep.
correct?
Yes,
Thank you.
okay. So no further questions. All those in favor say aye.
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 Anyone opposed? Seeing none, that motion carries. F5.
Okay. Item number F5 is another.
Thanks.
Hi, Sherry.
That's our farm. Can you see our farm behind me? Thought I'd show you.
I want some lettuce.
Yeah, come on down. All right.
I need to make some salad.
Yep. Aloha.
Thanks, Sherry.
F5.
Yeah, item number F5. LMD is seeking the approval to issue a right of entry to Alpha Inc., Honokoi, Maui, TMK number 244002, portion of parcel number 18.
We have a motion to consider staff recommendation.
So move.
Second.
Second.
Okay,
Again, the issuance is for a 12-month period. It's covering the subject area described below for the purpose of staging area and to stockpile aggregates and trench spoils for County of Maui projects Napili 3 and Napili 4 force main replacements.
are there any questions? Okay, so we have somebody representing Alpha Inc. in the
I believe
waiting.
it's Bob Young. Is that Bob Young?
Just standing by to answer any questions.
If anybody has any questions.
Yeah, I have a question.
Go, Randy.
Yes, so part of what they're going to do is some of this will involve some cleanup, yeah, from industrial level dumping, is that correct?
Correct.
Okay, and then the installation of 2 gates to mitigate trespassing
Traffic.
issues?
Yes, sir.
Okay, thank you, that's good to know.
Okay, any other questions? Okay, seeing none, all those in favor say aye.
Aye.
Does anyone oppose? Seeing none, the motion carries. F7.
Item number F7. LMD is seeking the issuance of a license agreement to Kukulu Kumuhana o Anahola, also better known as KKOA, on the island of Kauai, TMK number 48003, parcel number 19.
Okay, we have a motion to consider staff recommendation.
So moved.
Second.
Okay, thank you.
Okay. Kumuo Anohola is seeking again a license for 5 year. The term listed there for 5 years, and will effectively commence as of the date that the license is fully executed. The term of the license may be extended for 2 additional 10-year periods at the option of the chairman of the Hawaiian Homes Commission. Should licensee consider this option, the licensee must apply for the extension 6 months prior to expiration of the term, and the approval shall be subject to the Hawaiian Homes Commission review and evaluation of license operation status. Kaipo, if you have any, I have Kaipo Duncan, our land agent for Kauai. If you have anything else to add regarding KKOA.
No, I don't, but they're here too.
Okay, we have a representative in the box, so to speak. But commissioners, any questions for staff for?
Chair, this is Dennis.
Yes, go ahead, Dennis.
Yes, so Kaipo, can you go over the due diligence comments from the department? How did they do on due diligence for the right of entry permit?
Aloha, Chairman and Commissioners. They've done all their due diligence that we've asked of them over the last 2-year period since they've had the right of entry. More recently, they have informed us that they want to do some building, such as comfort station. They have plans to build other storage type facilities on the property. And that permanent building, we informed them, triggered the need for them to do an environmental assessment prior to them initiating any permanent building.
So on the due diligence, project development schedule and timeline, further detailed during the, do we have a schedule and timeline for the long-term lease or license? That was in the due diligence in the first, on the ROE.
Ready.
I can answer that.
I don't think it's on.
Can't hear you.
It's on? Okay. Go ahead, Nancy.
Yeah, this is Nancy McPherson from our planning office. We work closely together on Kauai.
Yeah, what we've done is we've been working with them to understand their approach. And what they want to do is to, they're bringing the students from the nearby charter school into this project. They've been using the Mauka site to grow kalo. They've pretty much maxed out that site. And what they want to do is to continue their due diligence in doing the EA. They want to have the students be a part of that whole process. So it's really an educational kind of process. So one thing we have put on this license, proposed license, it's in the submittal, is that we want to work with them in the next 60 days to work on milestones, a timeline, a schedule for one, completing their EA for their master plan, which includes the permanent structures, and B, to basically complete all their other regulatory requirements. So
What we're going to do is really, spend the time with them. They have also gotten additional assistance. So they've realized that they need technical assistance, and so they've secured that. So folks are starting to help them with their environmental assessment. So we think that this is very promising. And so that's what we've committed to, is spending time with them over the next 30 to 60 days to work on exactly what you're talking about.
Okay, so as the commissioner, what I'm not concerned about moving forward, concerned about a change in the scope. That initially the ROE was for a garden, and now we're changing the scope, even though it was in the pictorial that showed some type of a structure. I just want to make sure moving forward that we have a successful process. And to have a successful process, you have to, and I know you've been talking with them for the past 2 years to try to get them in line. And I support the organization. I actually was involved in the KKOA when we did the propagation area. My wife and I did a lot of work there. We currently work with KKOA and provide meals to our community twice a week, and I commend them for everything they're doing. I just want to make sure that as we move forward, that we continue to keep our eyes on the program and make sure that they're making those milestones that we need to have successful process. And I know initially, and I spoke to you and also spoke to Kaipo, and the information that you brought out that says, don't rely on the department to assist you through this process. So now you're saying that the department is going to spend some time with assisting them, but still the action needs to be on their part. When you say we're going to put in a structure, who's your contractor? Where's the fund? I know they have some funding, but I don't want the funding to be pushing us towards something that we don't have confidence in it being built. So that's my only concern. I want to make sure it's positive. I want to make sure we are continually tracking it. So one of my comments on the proposal to the department is that I would prefer that the authority to add acreage up to 30 acres comes back to the commission. And the reason I'm asking that is that I want to make sure it's successful. I may not be on the commission when it comes back, but I want to make sure at least I lay the table for the next person coming in to say, is it still going in the direction we want? Are our beneficiaries online? Yeah, has the association reached out and made sure that we have beneficiary approvals for what we want to do as we move on? So that's important, that we're laying down the roots for a legacy that we hope is successful in the long term. So Chair, I would prefer that any additional acreage that we closely watch the due diligence to make sure it's completed 100%, and that the community, the beneficiary consultation, hopefully we won't be in COVID by then, we can get more people out. But that's very important to make sure this is successful as we move forward. We've had other projects in our area that didn't get the end result that a lot of folks wanted, and it sort of broke the community up. So I want to make sure, and I support KKOA for what they're doing, because they do have a wide scope. They've got a lot of folks involved. It got me involved. They have a lot of different groups and people they're pulling together. I just think we need to reach out more to that beneficiary community, the neighborhoods right next door, and say, here it is, let's get involved. Our cleanup, they were involved in our cleanup. That's very important. But I'd like to, I don't want to micromanage this, but I want to make sure that we're moving in the right direction and providing support, and make sure that we can have a successful community space.
Okay.
Thank you.
One quick question before we go to other folks. So with regards to number 3, if we just scratch chairman, would that be amiable to you?
Yes.
Okay, let's go to David, then Randy, then Russell.
Thank you, Chair. I don't know much about this project. Is this being funded by Omidyar?
What's the funding for the current?
Is this a Omidyar project?
Right
the
now, they
Ulupono?
have a grant from the Office of Hawaiian Affairs.
OHA. So this is not the Ulupono Initiative group.
No.
Oh, so it's
No,
a
no.
different one.
Yeah.
Okay.
Yeah.
And then is this a beneficiary organization?
Predominantly, yes.
They're formed as a beneficiary organization?
Well, maybe I should let Ray answer that.
Would you answer the question? What is the form of your organization?
You got to unmute. Right, there you go.
Yes, thank you. Aloha Chair and Commissioners. To answer that question, yes, we are, we're not an association, but we are a nonprofit that has 3 out of the 5, well, actually all 5 are beneficiaries. 3 of the 5 are living in Anahola. There's just 2 of us that are not living in Anahola, but we have very strong connections to Anahola.
Okay,
But all
thank you.
5 are beneficiaries.
Okay, thank
Thank
you.
welcome.
And I guess a question for Nancy and Kaipo. You know, the submittal says that you're going to be working in the next 60 days to establish milestones. Wouldn't it be more appropriate to establish those milestones before we issue a 5-year license agreement, so we know what we're getting into, and everybody knows what they're getting into? So it's not like, you know, we issue it and then there's these milestones that you guys work on that are not, maybe not achievable, or, you know, just there may be issues with those milestones. So
Let me just ask a quick question. I
Sure.
think it's a totally legitimate question. Are there any funding issues that would be jeopardized not having this decision today? In other words, your grant from the Office of Hawaiian Affairs, is there a deadline or something that you have to meet to have site control? Greater site
Yes.
control. I should say.
Yes, and also, I mean, not just Office of Hawaiian Affairs, because this project is not an Office of Hawaiian Affairs project. There's several grantors. We've even tried to seek grants from federal, but have not been able to acquire the longer term grants because we do not have the license of this property. I believe Kaipo and Nancy have also been working with the grant specialists to make sure that the funding that they've already approved, that we actually do have the license for the property. We're talking about $175,000. So that's a lot of investment on their part to be able to provide, and the license is very critical.
Okay. It is, but the normal process is you get the disposition, then you go get the grant, right? So,
right.
Yeah, it puts a commission in a very challenging situation. Is there?
Chair, could I?
David, sorry, David, would you be comfortable with sort of a conditional approval?
Yeah, I guess so, only because I don't fully understand what the milestones are. When I heard it was Ulupono, I thought it was Ulupono Initiative, right, which is the Omidyar Foundation. And then there's significant amounts of funds that are available for and they do agriculture as well, interestingly enough. But when I was reading the submittal, it seems like the group has had to scale down the project just to be able to fit it into an EA. I mean, that's what it says here, right? So that so that agricultural and educational activities can commence while KKOA continues its due diligence and environmental assessment related activities. So I'm not quite sure what's going on, because normally within the first 2 years, that's what you do. You do your due diligence and then you come for a disposition, in this case, a 5-year license. This seems to say they're going to continue to do due diligence, and I'm not I'm not sure how that fits into the overall picture, because that's not our normal pattern, right? So you come in, you do your due diligence, you come back with a proposal, this is what we want to do. You don't continue to do due diligence for the next 5 years. So I'm not sure what's going on. I'm not saying there's anything bad. I'm just saying I don't understand it.
Nancy?
Can I explain? Okay. Well, what I think we're beginning to realize in the planning office is that if you're a priority project in the regional plan, you can avail yourself of DHHL grants to assist you with doing due diligence, such as an environmental assessment. In this case, what has happened was that they did have assistance to do, sort of for the entire agricultural, which it really is a big mala. But they also put in things that were amenities. So what happened was they got grants to continue to implement this mala plan. However, because they were proposing things that we couldn't exempt based on our exemption list, we had to say, okay, we got to put the brakes on. Let's carve out a section of this that is basically agricultural activities that you can do without having any permanent structures. And we can issue an exemption, which we've prepared that exemption, so that they can have a presence on the site. The other thing is that there has in the past been dumping, people have set fires, there's, the rubbish. They've managed to fence it, but people keep coming and cutting the fence. And, they thought that, well, until, they've done all this due diligence, they can't really even go on the site. So what we have worked out is a strategy where we can issue the exemption. They can continue to do the studying of the site as part of their educational activities. They can do agriculture, which is actually an exempt activity. The land was previously in sugarcane cultivation. They can use their grant money to do these things. They can complete the EA, and then they can do the things that we couldn't exempt that they need the EA
So
for.
the structures would be coming to.
They want to drill a well for irrigation. So yeah, as the thing is, as part of this, it's kind of a moving target. You start uncovering that, the water meters are really expensive. If we can't figure out how to get more agricultural water, that's really going to limit us as to what we can do. Basically the site is formerly, plantation ag. So what we're trying to do with them is to say, we want you guys to have access. We want you guys to have a presence. We want you guys to be cleaning and clearing and doing all of these things. They've run out of room for their colo, so they want to start planting colo down there. They can install the water meters, but to do anything more besides having some storage containers on there, they're going to have to complete the EA and get a FONSI. Now, the thing is that EA is going to come back to this commission. So you guys are going to be a part of that. The other thing that's starting is the Anahola Regional Plan update. So what we're seeing is this is actually an opportunity, as Commissioner Nevis talked about, to engage the greater Anahola community, work out, who wants to do what and coordinate, and then get these things in as priority projects. And then that's going to make even more resources available for these kinds of things. And we're just talking about a 10-acre site right now. The other additions, that was kind of part of a really bigger plan. But right now we're just saying, let's just start with 3 acres on the 10-acre site. You can do some ag stuff there, do your mala, while you work on the EA for the entire 10-acre site. And then we'll go from there. Once that's successful and, worked out all the bugs, all of that sort of thing.
Okay, thank you. I'll go back to, would you consider a conditional?
Yeah,
Okay.
that's fine.
So it's condition, the approval will be conditioned upon the
milestone.
the work plan that they're working on. Okay, so there are questions from Randy, then Russell.
And Patty.
And Pat.
Yeah, thank you, Chair. So I'm confused by this proposal and situation. And it's not that I don't recognize the value of what this organization brings. And currently, they're comprised of all Native Hawaiian beneficiaries, but I don't know if the nonprofit requires that a percentage of their board members are perpetually required to be, you have a percentage of Native Hawaiian beneficiaries as part of your board. So that's one of the questions I have, and I asked that because in this license agreement, the organization can get upwards of 25 years because they get the initial application is for 5 years. Then with the opportunity to extend for 10 years twice. So that's a very long-term disposition. And my question is, when we're going 25 years out, how many of our beneficiaries are we serving as part of your business model, for lack of a better term? And then, Nancy, so what I'm hearing is they were granted an exemption to engage in certain activities connected primarily to a large mala, right? Okay, and it looks as if, so now they get the grant before you come to us for an approval. And what I'm hearing is, in order to spend the money or qualify to spend the money, they now need to get us to approve the license when they already got the grant money. So that troubles me too. It's not what the organization brings to the table. It's the process that really concerns me. And before I forget, Dennis, you had mentioned that when it comes to adding acreage, that it come before the commission, which I agree. What I did not hear, and maybe I missed it, because what I want to add is that in item number 1, they can also come before the chairman to get extensions on the license agreement for a total of 20 additional years. So I would like to add that in, that it come before the commission as well.
I agree.
I'm sorry.
I agree. I missed that. Sorry.
So
Randy,
yeah, I'm just confused. It's late in the day, but I see some red flags popping up on process that concerns me. And the reason I think we need to ask these questions, because other beneficiaries look at how we make these awards, license agreements. How is it going to benefit long-term our beneficiaries? So this is why I'm asking the questions. Thank you.
Thank you, Randy. So would crossing out chairman in the second paragraph of number 1 address your concerns? Because it would just require it to come back to the commission.
Yeah, so that was just one concern.
Okay.
I have a litany of other concerns. I'm not sure if I'm laying it out clearly at this hour of the day, but I have concerns.
Okay.
Chair, another thing, I'm sorry. Go ahead, sorry.
I was gonna say, go ahead, finish Dennis, then we'll go to Russell, then Patty.
Well, yeah, just another question, correction on page 3. The third paragraph is requesting a 30-year license. However, staff recommends 10, and that should be 5.
Should be 5, yeah. Thank you. Russell, and then Patty.
Thanks, Chair. I was noting that same correction, and then one more. I just want to make sure, item number 8 in the recommendation. Kahana, it says DHHL shall issue 1 5/8-inch water meter at no cost. And then in the discussion, it talks about a water meter credit to be issued at no cost. So we're not talking about the physical equipment. We're talking about the entitlement to draw water, right? From the credits that we have, the department has. So
Yes.
there's no out-of-pocket costs for the department under item 8 to
Correct.
issue a physical water meter.
Correct.
It's a water meter credit, okay.
Right.
And then, so Chair, I was gonna just give my opinion. I think I've heard Commissioner Nevis, and it sounds like he's in support of KKOA and what they're doing. I'm okay with your suggestion to do the approval of the license subject to working out the milestones, because that requires staff and KKOA to get together and figure that out as quickly as they need to. I'm also okay with the non-standard, I guess, timing or process that has been gone through, because I think, I've lived through other projects myself where, you're doing good work. You're just trying to keep up, and you're trying to get funding, and you're trying to get people together and all that kind of thing. So, there's an ideal way to do it, but that isn't always followed. But if you have the right people, and it sounds from Commissioner Nevis that they have the right mission and in mind. So I'd be in support of approving, notwithstanding the a little bit out of sync with the process.
Okay. Thank you, Russell. I mean, not everybody starts off knowing how to be organized and how to do all of this.
Exactly. Yeah.
I want to recognize the enthusiasm of the group and the desire to make positive changes in the community. Patty?
Thank you, Mr. Chair. Just listening to other commissioners, I have a question on item 8. It says DHHL shall issue 1 5-inch water meter at no cost. So is the department taking the cost to install the water meter?
The fee in the next section covers the installation.
$275?
Yes, so we have water credits available to us. So the water credits are really what's
okay.
What number 8 refers to, that we can.
And
use
the
our
other
water
thing,
credits.
who also pays for the environmental assessment to be done? The nonprofit?
Yes.
Correct.
Oh, okay. And I just wanted to make mention with Kumuhana Anaola, your grant from OHA is $75,000, and your grant, your summary to OHA was for the use of water systems for 7 acres of land on Native Hawaiian beneficiaries in Anaola. So what are we talking about? This 7 acres here in this submittal? This grant that you're receiving from OHA is to provide for your water system for 7 acres. Is that correct?
Yes.
Okay. And just noted, FYI, your grant will end in 2022 in OHA's. It will overlap. It will maybe overlap, so you'll lose it if you don't use it. you have 9 months of
Yes.
using that $75,000 of grant submittal from the Office of Hawaiian Affairs. But, all right, thank you very much.
I believe they have the ability to request an extension of their grant if they should show progress moving forward, so.
Yeah, and that is good if OHA does an extension for your grant, what you call request. But I just wanted to know about the purpose of the grant usage of $75,000. Thank you.
Mahalo. Dennis?
Yes, Chair, I just want to clarify. It seems now it's very important that we get to schedule a milestones in 60 days. I know the department's going to work with them, but it's really going to be on their side. They've procured grants on the assumption of getting a long-term lease, and we know that's a little backwards, but I don't want the commission to be forced to move because they have grants. They need to get those grants ironed out, possibly get some extensions. The 60 days is going to be important as to a specific plan so we can get things in order. And I understand they have lots to do. They stay busy with a lot of other things, but I just want to make sure that it's a successful program.
Okay, thank you. And I'm sure you'll be watching the milestones and helping us maintain.
Mr. Chair,
Yes, I will.
Yes,
Pauline Namuo.
go ahead.
Mr. Chair, I am not in support of this
Okay,
because there is no plan. But I am in support of everything Commissioner Nevis has said. And I think he is giving them a chance to actually produce what he feels they need to produce. And as a commissioner, I think that he's giving them a chance to do what we think beneficiaries should do. And because we don't have any real plan to look at, I'm not really in support, but I will vote in favor based on the premise that Commissioner Nevis has confidence in them and he is on Kauai and we'll make sure that happens. Thank you.
thank you, Pauline. Okay, so we are going to amend the motion. We'll have to amend the motion. Somebody will have to make a motion to amend the motion. My suggested language for the motion is that the Hawaiian Homes Commission authorize the issuance of a 5-year license agreement covering the subject areas identified and described in the submittal, conditioned on establishing milestones with the department within 60 days. So I need someone, I need a friendly amendment from the seconder Helm and the motioner Pauline.
Chair, also those corrections in paragraph 2, number 1, paragraph 2, and paragraph 3. To remove.
Yes.
Is that correct?
Yes, as described in the submittal with the corrections.
Thank you.
David?
So just one question. So is the intention that within 60 days, we will see the milestones and at that point we'll give final approval?
We could. They need the conditional approval will allow them to deal with their OHA issue.
Correct.
And then coming back in 60 days with the plan will allow for you to remove the condition and give a final approval.
Right. Or if the milestones have not been, in the worst case scenario, if the milestones have not been laid out or the milestones are not approved by the commission, then it may not go forward. I just want to make sure that that's on the table. Is that correct?
Yes.
Okay.
That would be the procedural.
Okay, thank you.
All right.
Am I able to say something?
Yes, go ahead.
Sorry. Well, one, I just want to thank all of you for even considering the submittal and the work that we're doing. I can understand some of the confusion that you might see right now. But maybe to put into some perspective, our property lies, we're the first 10 acres right across of Pi'ilani Maikekai subdivision. And right behind of us is all the work that Jeremy Makepa and several other organizations have been clearing. So to just kind of give you a perspective of where we're located, we actually started the process of removing all the vehicles from that area. And we were very thankful that Jeremy came along and saw the need to also clear the back portion because of the danger, not just to the community, but to his firefighters. As far as the milestones and the plans, we have given all of our updates on different things that were required of us. And there were additional things that I think DHHL had requested. So it's true, we've been trying to keep up with the different areas that have been requested of us. But in the meantime, we have had a community that has shared their priorities, which is, they gave us 3 top priorities, which was education, their culture, and building life skills. So everything that Keikoa has tried to provide for the community, we just really feel that we've come as an advocate of the beneficiaries in Anahola community. So at this time, because we have not been able to get a license for the project, we're thankful that we're given a smaller area. But through that, it's the community that has been coming to us. And like right now, we have 30 students that come up to this smaller property because the school in Anahola, Kanoi Kapono School, needed help. They can only have a certain amount of students on their campus. So we adjusted. We adjusted to assist the community. And you know, in all of the different needs that the community has had, Keikoa has just tried to do, just like Commissioner Russell has said, we do what we can do. And I think we felt that we did accomplish certain milestones that were asked of us. We have our civil engineers, we did the surveying of the land, we've done the soil testing of the land. We've brought in different partners that they're ready to go. But we just really need your support in this. And to be able to have the license of the land will help us to provide the programs that the community needs. And I mean, even with the work that Jeremy has been able to accomplish, you know, it's kind of like the 2 of us would be up till 11 o'clock at night trying to figure out the plan of how we're going to get people to come and help. And we're just thankful for each other and all the different people. We have the kupuna that actually helped us put up the fencing for the property. And so when there's destruction of that because of the drug activity and the homeless activity, to us, it's not just a broken fence. It's our kupuna that was there.
Can I just say that we understand what it's like to try to organize in the community. However, you're asking to partner with the Department of Hawaiian Homelands through the commission. And it appears that you have lots of good ideas and lots of phased plans. What the commission is strongly urging right now to get this approval is that within the next 60 days, you work with staff and come up with a set of milestones, not for the projects that you're going to do 5-10 years down the road, but to initiate settlement of the 10 acres with the resources that you have. And let's demonstrate some more progress so that we, the commission, can allow you to further progress once these conditions are met, okay?
Okay.
And we do appreciate all the community work that goes in there. All of us, I'm sure, have at one time or another done our time in the barrel and done community work, and we know how difficult it is. Okay?
Okay.
Okay. Mahalo. So we
Chair?
have an amended.
Chair, if I could.
Yes.
So I just want to say to our testifier that William, you've covered a great deal of what I was going to try to say. But you know, I think if there's anything I would add on is that, again, we don't question your effort, your integrity, the value that your operation brings to our community. But I do feel very strongly that part of our responsibility and the responsibility of the department is to help to guide you to a better place than where you're at now before it comes before us, because in order to support you in your project, we need to help you understand what the requirements are before you come here. And so you're here, and so this conditional approval is intended to kind of work backwards to get you where you need to be so that we can revisit this issue. And when I hear the term moving target, I get it, I understand that. But what we want to do is make sure you're not a moving target, that we bring stability to your plan so you have long-term security in moving your ideas forward, so that well into the future, you're serving your community with a level of certainty that you can continue. So anyway, that's where I'm at. Thank you.
Mahalo.
Thank you, Randy.
Chair, just one comment.
Go ahead, Dennis.
Well, Ray, thank you for your testimony, and we, I totally understand. I work with you week on week, watering plants, cultivating. You bring a lot. Your organization brings a lot to the community, but this commission isn't here to deny. This commission is here to make us all successful. The beneficiaries, your organization. So just understand that we need to have things in order. So as we move along, and we continue to work with you to be successful. So I appreciate everything you're doing for the community.
Mahalo.
Thank you. And with that, I will ask for a vote on the amended motion. I believe everybody understands what we're voting on. So no.
Can you repeat the amended motion, please, Mr. Chair?
No, I will read it. So the amended motion, the motion be amended that the Hawaiian Homes Commission authorize the issuance of a 5-year license agreement.
I'm waiting. I can't hear.
Yeah, so somebody's got a party in the back going on. Could you tell them to be quiet? The amended motion, the motion is amended that the Hawaiian Homes Commission authorize the issuance of a 5-year license agreement covering the subject area as identified and described in the corrected submittal, i.e. removing the chairman from conditions 1 and 3, conditioned on establishing milestones with the department within 60 days. That is the motion.
Who made the motion?
The makers of the original motion, Helm and Naumo'u, consented to the amendment.
Thank you.
All those in favor say aye.
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 Anyone opposed? Seeing none, the motion carries. Thank you, Kahana.
Mahalo,
Thank you,
Good
folks.
luck, Rachel.
Thank you, thank you.
Thank you.
Rachel.
Hannah.
Good luck, Michelle.
Mahalo.
Thank you.
With your indulgence, I'd like to take a 5-minute break and then we'll come back and do the rest of the agenda. Okay. Aloha, Commissioners. Welcome back from recess. Ryan, are you there?
Yes.
Okay, Ryan, what I'd like to do, and I need some advice from you, is I would like to recess the regular commission meeting, go into the one contested case that we have, finish that contested case, and then come back to the regular meeting. Do I just recess this meeting? And it's not an executive session, but it is contested case.
It would not be an adjournment. It would be a recess.
Okay, so I recess this meeting, call to order the contested case, and then come back from recess and start the meeting, regular meeting back up again. Right?
Yep.
Okay, commission members, you know what the intent is? We're gonna recess the regular meeting and then call into order the contested case. Ursula Chong, read Department of Hawaiian Homeland Designation Successor for Residential Lease number 2679A, lot number 64, Kuhio Village. Is he handling the address?
Can you go off?
I have
Sorry.
to go off public. Julie, can you exit and come back?
We're not live.
Okay, and the live feed's got to be taken off too. Yeah. Hey, commissioners, we're back in session and the next agenda item is G7. Sorry to interrupt that interesting
G7,
conversation.
okay. Okay, G7.
Andrew?
Are they in the? Okay. And Leslie too. Yeah. Okay. Aloha Commissioners, item G7 for information only. The draft environmental assessment for the Barbers Point Solar Project in East Kalailoa, Tava District, Oahu, and anticipated finding of no significant impact. Just for a little bit of background information, in July 2019, the Hawaiian Homes Commission authorized the chairman to issue a right of entry permit to Interject Renewables USA LLC to conduct due diligence activities to assess the potential of developing a solar project in Kalailoa, island of Oahu. The completion of the draft environmental assessment report is part of the due diligence activities that the company has been undertaking over the last 2 years. The purpose of this informational briefing is to update the Hawaiian Homes Commission on the proposed Barbers Point solar project on DHHL land in East Kalailoa, to present summary highlights of the draft environmental assessment, and to notify commissioners of the draft environmental assessment prior to publication of the Office of Environmental Review Programs, the environmental notice periodical. With us today, representing the company is their consultant, Leslie McLean from Tetra Tech. Tetra Tech produced the draft environmental assessment, and I will turn it over to her. Go ahead, Leslie.
Thank you. Did you want me to share my screen with the PowerPoint, or will you be? Oh, there it is. Great. Wonderful. Okay, so you can go ahead and advance to the next slide. So aloha and thank you for your time today. My name, like Andrew said, is Leslie McLean, and I'm a planner with Tetra Tech. And we prepared the draft environmental assessment for the Barbers Point Solar Project. And so, as Andrew said, the purpose of this meeting is to kind of check in with the commission and the updates on the project and summary highlights of the draft environmental assessment, and to let you know that we are planning to publish the draft EA next month. Next slide, please. I know this has been a long day and we're going to try to keep this presentation brief. So I'm going to kind of go over things pretty quickly, but we have several people on the line to answer questions at the end of this presentation if you want to go more in depth on any of these topics, including my colleague Mara Mulrooney from Pacific Legacy, who completed the archaeological inventory survey and the cultural impact assessment. So I'll quickly go over our project description, project background, summary highlights from the EA, and the criteria for the finding of no significant impact, and then we'll end with the schedule update. Next slide, please. So the Barbers Point Solar Project is a solar plus battery energy storage project located in East Kalailoa, and it's primarily located on 2 DHHL parcels that you can see here on the slide. The first parcel is the parcel 91013-038, which I'll refer to in this presentation as parcel 38. And the second parcel is 91013-040, which I'll refer to as parcel 40. In addition to the 2 DHHL owned parcels where the solar facility will be located, the environmental assessment also includes in the project area the HDOT right-of-way of Coral Sea Road, because there will be a generation tie line that will take the electricity from the solar facility up to a point of interconnection on the existing Hawaiian electric grid near the intersection of Coral Sea Road and Roosevelt Avenue. All right, next slide. This next slide is going to show you a figure that is a little bit more zoom in of the project area, and it shows you a high level layout of the project facility. So this project is 50 megawatt ground mounted single axis tracker solar voltaic system, and it includes a 60 megawatt hour battery energy storage system. The total project area that's outlined in the bright yellow boundary includes 163 acres. However, the total footprint on the DHHL properties will be less than 100 acres, and of which the solar panels will be approximately 45 acres. And then the other thing to point out is that the project's organized into 3 main solar array areas. So there's area 1 that's in the northern end of parcel 38, area 2, which is on the southern end of parcel 38, and then area 3, which is down on parcel 40. And I can give you more details on the layout as if you request it at the end of the presentation. And then the one last thing I want to mention is that access to the parcels will be from Coral Sea Road. Okay, next slide. So some project background, the commissioners should all already be familiar with this, but just to go over it quickly, these 2 DHHL parcels were transferred from the US Navy to DHHL in 1996 as part of a settlement agreement under the Hawaiian Homelands Recovery Act. And then in 2010, the DHHL prepared the Capital A Regional Plan and designated the 2 DHHL parcels for mixed use and intended them for revenue generation rather than residential development based on the fact that these parcels lacked infrastructure, and that also because of their location near the airport. In 2014, the Oahu Island Plan was prepared and it designated those 2 parcels for industrial use. And then some other things to note is that the project directly supports Objective 2 of the Ho'omalu'o Energy Policy, as well as the Energy Partnership Charter that DHHL and HECO entered into in August 2009, which is an agreement to work together to achieve energy self-sufficiency and sustainability, and includes the leasing of lands owned by DHHL for renewable development. Next slide, please. And a little more project background specific to this project is that those 2 parcels, parcel 38 and 40, were part of a competitive solicitation process in 2018 and 2019. DHHL ran 2 consecutive solicitation processes. And the result of those is that Interjex / Barbers Point Solar LLC was selected as the final applicant to move this project forward and continue to do due diligence. So in July 2019, the Hawaiian Homelands Commission authorized the chairman of DHHL to issue the right of entry to Interjex. Next slide, please. So as part of the due diligence, and because the project's located on state-owned land, this requires an environmental assessment be prepared under the Hawaii Revised Statutes of Chapter 343. And so part of that process, we conducted a number of technical studies, and you see the list here on this slide. And to note that the archaeological inventory survey has been completed and it has been submitted to SHPD, and they're in the process of reviewing it now. The cultural impact assessment was also prepared and is included in the draft environmental assessment, along with copies of all the biological resource surveys, the visual impact assessment report, the glare analysis report, and the transportation impact analysis. In the next few slides, I'm going to go over the highlights of some of these key resource topics that are in the EA. Next slide, please. So to start off, historic properties. The archaeological inventory survey resulted in the identification and documentation of 17 historic properties. And of those, they contain a total of 438 archaeological features. This figure that you see on your screen shows you the distribution of these features, and they're color coded. So the blue ones represent the historic features that are non-Hawaiian sites that are more related to the historic military use out here. And the pink ones, the pink dots, are limestone pits, while the purple dots, which are mostly clustered in the southeastern side of parcel 38 and the southern end of parcel 40, are the pre-contact Hawaiian sites. Let's see. We'll go ahead and go to the next slide. Of the 438 total documented features to be preserved, 348 will be, of the 438 documented features, 348 will be preserved. And of those, that includes most of the traditional Hawaiian features, including all 8 of the ceremonial features that were documented and most of the limestone pits. Of the 90 features that will potentially be impacted, 42 will be mitigated through data recovery. And then 48 would be considered for recommended for no further work because they've been adequately documented. And those 48 features that are recommended for no further work are all associated with the military infrastructure from the mid-20th century. We're anticipating that SHPD will come to effect determination of effect with proposed mitigation commitments. And like I said, Mara's on the line, so she can answer any questions you have regarding the results of the AIS or the recommended treatment for each feature in the historic properties. Next slide, please. So to touch base on the cultural resource topic, the cultural impact assessment was prepared and included sending out scoping letters to 15 individuals affiliated with a range of organizations. 6 individuals responded, 1 providing email correspondence, and 2 participated in formal interviews. And there was a site visit on June 17th with these 3 CIA participants. But we've also done several other site visits with stakeholders, as well as lots of other community meetings outside of purely the CIA effort. But the June 17th meeting was specifically for the CIA. Next slide, please. Before I forget, Pacific Legacy also delivered an informational presentation to the Oahu Island Burial Council as part of their outreach for the AIS and CIA. So as far as the sort of the results of the CIA, collectively those interviewed shared important oral traditions specific to the region and emphasized significant archaeological features, including the presence of trails, the use of the limestone sinks for the interment of Iwi Kupuna. And they also noted cultural practices such as gathering limu and other coastal resources, as well as traditional agricultural practices that were carried out in the wider region. Based on information shared by Uncle Shad Kane, portions of the project area were also used by Hawaiians for a variety of activities. For example, pits in the larger general area were utilized as natural planters for dryland crops, temporary shelters, storage features, and sources of water. Shad Kane also recalled the existence of a kahua or a makahiki grounds, as well as numerous trails in the area that connected to the trails over in the Kaleloa Heritage Park. No evidence was found of ongoing cultural practices in the project area, and the CIA participants did not identify any direct or indirect impacts that the project would have on traditional or customary practices. Next slide, please. However, the potential for limestone pit features in the area to contain ancestral burials was a shared primary concern of those interviewed during the community outreach efforts for the AIS and the CIA. So an archaeological data recovery program will be developed and an archaeological monitoring will occur during construction. And the cultural descendants who participated in the CIA will be further consulted to develop protocols for appropriate protection and preservation of the sites. Next slide, please. So to kind of quickly go over the biological resources at the project area, we've conducted a number of biological surveys in 2020 and 2021, including general plant and wildlife surveys, Pueo survey, and a COCO survey. And the Akoko survey was not only in our project area, but also within 100 meters outside our project area on an adjacent Navy-owned parcel where there was known Akoko to exist there. In general, the surveys found that the project area has been extensively disturbed by the previous military use and also the introduction of the invasive species out there, which has resulted in a reduction of native species in suitable habitats for native species. Next slide, please. No listed plants were observed in the project area, and the majority of the wildlife that was observed is non-native, but there were native species observed in the project area, and we've been working really closely with the U.S. Fish and Wildlife and DOFA to make sure that the project implements appropriate minimization and avoidance measures to ensure that there will be no impact or no significant impact on native or listed wildlife. And I could go into more detail about what those avoidance and minimization measures are if anyone has questions about that at the end of the presentation. Next slide. Visual resources, in general, we're expecting to have minimal to no significant impact on visual resources. We did conduct a visual impact assessment, including a number of visual simulations with before and after shots which I have loaded up as additional slides that we could go to if you have questions about those. They were also, the simulations were also included in the draft EA that you should have received a copy of. Generally, the project won't be discernible at locations outside of the project area. It'll mostly just be in places right next to the project boundary where there'll be views in between the existing veg that would be remaining. Next slide, please. The second to last topic is glare. We performed a glare analysis and have been in coordination with the FAA, specifically to look at potential glare issues related to the Kalaeloa Airport runways. And we found that there would be some limited glare at those runways, but none of the harmful glare, which is the yellow and red glare. And we consulted with FAA and did receive a determination of no hazard to aeronautical activities. So we have a copy of that included in the draft EA. All right, next slide. And real quickly on transportation and traffic, the project's not expected to have a measurable effect overall on the traffic. There will be some temporary minor impacts during construction, but a traffic management plan will be put in place to minimize those impacts. And then during the operational phase, there will be little to no impacts on traffic or roadways because there's really not very many trips that are required for the operation of the facility. Next slide, please. So in conclusion, based on the analysis completed in the draft EA, the DHHL staff anticipates a finding of no significant impact for the project. And that determination is based on the 13 criteria of significant that's in the Hawaiian Administrative Rules 11-200.1-13. And I can walk through those criteria more specifically if anybody would like me to at the end of the presentation. Next slide, please. So the next steps for completing the environmental review process will be to publish the draft EA and the anticipated finding of no significant impact on October 8th of next month. And that will kick off 30-day comment period, during which we plan to host a virtual open house on October 20th. And then after the public comment period is ended, we'll take all those public comments and we'll look at them and we'll update the draft environmental assessment to address concerns and questions that people have. And then we'll come back to you and present this final environmental assessment to the commission. And we'll be at that point be asking for a declaration of a finding of no significant impact. And then after that commission hearing, then we would move forward in January to publish that final environmental assessment and FONSI in the environmental notice. Next slide, please. In addition to the environmental assessment and HEPA process, there's a number of other reviews and approvals that will have to be obtained before construction. This slide lists them all for you. There'll be a number of discretionary permits that will be going to Hawaiian Community Development Authority for. We were requested by DHHL to work with HCDA on these. And then to kind of sum it up, the construction start date we're hoping for is by the third quarter of 2022, and with hopefully to have operations started by the end of 2023. So I'll stop there. And like I said, we have plenty of other slides that we could share. Happy to answer questions. And Mara is also on the line to talk to anything related to archaeology or cultural resources. Thank you for your time.
Thank you. Commissioners, any questions at this point? I can't see you. Okay, now I can see you. Are there any questions, commissioners? Okay, seeing none.
No. I have a question.
Go ahead. Hang on a second. Patty, David raised his hand first. David?
Go ahead, David.
Thank you.
You're welcome.
So Leslie, with the solar array, how are the cultural sites going to be protected? Are they going to be placed around them?
I would say majority of them are going to be avoided. In fact, many of the, I guess, the ceremonial sites will be actually outside of the solar array fence line. So they would be, not even close to our footprint of disturbance. But if Mara, are you able to chime in on that question? Great.
Sure. So as part of the AIS, we've made a number of recommendations, including preservation of the majority of the sites. And so what we'll be doing as a next step is developing a detailed preservation plan for all of the sites that are recommended for preservation, or all of the features in this instance. For all of the native Hawaiian sites, we'll be recommending a buffer of at least 10 meters from any project infrastructure. For the military features that are being recommended for preservation, we're going to be recommending a buffer distance of 5 meters. And for the unmodified limestone pits, which are mostly the smaller ones that are going to, some are small and some are large. So for the unmodified pits, we're recommending a buffer distance of 3 meters. So that's a 10-foot setback of any project infrastructure. Now, in terms of the data recovery sites, there are some sites that will be impacted, some features, and this includes the vast majority of them that will be impacted are unmodified limestone pits. Many of them are some of the smaller pits. They haven't been modified by the addition of a stacked wall around them or any other cultural modifications. But we do know that these are culturally sensitive natural features on the landscape that were sometimes used, of course, for things like gardening, also sometimes for the interment of iwi kupuna. We have not identified any burial features within the project area, so we'll be confirming that those pits do not contain human burials. They're also known to include paleontological remains, so the remains of now extinct land birds, for example. So we'll be keeping an eye out for that as well. Now, in addition to the unmodified pits, we also have 8 additional features that are being recommended for data recovery. These include some of the smaller mounds and wall segments as well.
But the data recovery, you're going to then preserve them, or they will be not preserved?
They will be
after data recovery.
After data recovery, they will be impacted by this project. They will not be preserved.
And so, but any site or pit that is being impacted, you will do the archaeology to recover any data that may be contained in therein.
That's correct.
Okay, thank you.
Mm-hmm.
Other questions, commissioners? Patty?
My question is, I don't know, is a CBRE projects on hold at this time, on a pause with RFP moving to HECO?
That's a good question, Commissioner, and those projects will be covered in agenda items G5 and G6 shortly after this presentation.
Okay, I was just curious how the process would move forward with the RFPs going through HECO. And the other question I had was, I know Mr. Ka'apu touched about our burial archaeological sites. Will you also be looking for native Hawaiian plants there? I understand Uncle Chad Kane, if that's the site that I know that he took care of as our Kapolei archaeological individual. He's very well known in that area of Kalailo and that parcel. And I know there's several native Hawaiian plants. I remember when we went to his tour, Kaunaoa and some other plants. So how is that will also be looked at when you move forward in your project?
Yeah, I can answer that question. We have documented all the native plants that were observed during our biological surveys, and we did a particular effort on okoko, especially because the okoko that's located in that area is very rare. And we looked very extensively because we've been working with the botanists at DOFA, and they're very, very interested in this, and they know exactly the history of the okoko in that area. That's primarily on that Navy parcel that's between the two DHHL parcels. So in the concern partly with the okoko in particular was that not only is it that we want to make sure that it's not in our footprint, but also within a buffer zone of the footprint so that you don't have other types of indirect impacts that could affect the Okoko. So that's why we went down, we got authorization from the Navy to go down on their parcel and do a pretty extensive survey for this 100-meter buffer adjacent to all, from like buffered out from the extent of our disturbance area on the DHHL parcel and also on the Coral Sea Road right away. And we didn't find any Okoko within those buffer areas, but we did find Okoko outside the buffer area, so further from 100-meter, and got some beautiful pictures of it. It was very exciting. So that we are aware of that species. And then we found some willy trees up on parcel 38, and we're going to be avoiding, I think, all of them, but definitely we're making an effort to avoid them. We're knowing that even though they're not protected by the law, they are culturally significant and relatively rare in that ecosystem. So we are making an effort. I can't say that.
Thank you for that. And so what about the Kapolei Pu'eos? Have you talked about that with the community or Chad?
Oh, the Pueo? Yeah, we did a specific Pueo survey, and we did see one morning during this, because we do these early morning and then evening sunset and sunrise surveys. So we know they're around, and I think we knew that even before the survey. So we've been working with DOFA on specific minimization measures for doing surveys for nests before construction. And then if one's found, then there's a whole process of stopping construction within a certain buffer, continuing to have a biologist come and check the nest to make sure that they've left before we continue to do work in that area. There's a lot of similar habitat in the area, so we don't believe that it's going to significantly impact the Pueo to take out the Kiave, for example. Some of the plants that are out there right now to put this project in, but we will be working with DOFA closely to make sure there's no direct impacts to any Pueo that might be nesting in the area before and during construction.
And lastly, I'm just as curious, in your permit request, you have requested, you have a CUP. Can you explain why are you requesting a CUP permit request for that?
Well, that's with HCDA, and they, although technically they don't have authorization over DHHL properties, the DHHL staff has requested that we go ahead and go work with them on getting the permits that they would require, as it's sort of more like just making sure that we have health and safety in mind, just like we're going to go get grading permits from the county and all the permits that are required. But so HCDA's land use requirements for their plans for this this Kalaeloa area requires a conditional use permit and a development approval.
So with that, along by the conditional use permit, the CUP that you're requesting, will that go to the County Planning Commission and public hearings?
It goes to the HCDA board.
Okay.
Yeah.
All right, thank you.
Yeah, we'll go
Thank
to
you.
county for building permits, but everything else will be HCDA.
Thank you very much. Thank you, Mr. Chairman.
Thank you. Any other questions? Not Andrew, thank you.
I'd just like to thank Leslie and Mara for hanging out this entire afternoon and waiting
thank
patiently.
you.
So thank you.
Always.
Thank
Thank you, Andrew.
Thank you.
Next agenda item, G5.
Aloha.
Okay, aloha commissioners. So this is a decision-making item. So the recommended motion is that the Hawaiian Homes Commission accept the beneficiary consultation report for a long-term lease with Nexam Inc. for a proposed community-based renewable energy project in Kalawa, North Kona, island of Hawaii, TMK 373010007. With me today, I have Julianne Cachola, the lead planner on renewable energy projects in the department. And I'd just like to caveat that Julie's going to give a little bit more context about the CBRE program, like Commissioner Taruya had requested information on in the previous submittal item. So she's going to talk about the consultation report and the results from that, but she will be giving a larger context about the CBRE program that HECO is proposing, community-based renewable energy. Sorry, CBRE is community-based renewable energy. And also just a quick overview of the solicitation process that the department went through to arrive at this point, since I don't think we updated the commission in recent months about this solicitation process. So with that, I will hand it over to Julie.
Thank you, Andrew. I need to be able to share a screen. Somebody needs to enable me.
Hi, Julie.
Hi. We'll try, I know you guys have had a long day, and we'll try to do this as quickly as possible. But you know, we're looking at public hearings being conducted soon, and you know, we've done this presentation to the community, but we realized that we hadn't. The commission has not necessarily seen this presentation, which is why we want to go through it so that you be prepared and for the public hearings when that comes up. Okay, thank you. Got it.
Okay, go ahead. You can share, Julie.
Yeah. Okay, so are we looking at my screen? No?
Yes.
Okay. So yeah, so this is really a presentation on the two beneficiary consultation reports, and it's for two proposed community-based renewable energy solar projects, one in Kalawa, one in Kauai. So the G5 is for Kalawa, the G6 is for Kauai. Why? So in terms of the beneficiary consultation meetings for Kauai, we conducted one in December 8th and another one on July 26th. And the December 8th one was when we just came up with the solicitation. We didn't have any you know, applications in. We certainly had not selected any developer, but by July 26th, we had selected a developer. So we were able to introduce the developer to the community. We sent out invitations to 187 Kauai lessees. You know, these meetings were not well attended, but we've been running them on our website. So we know that people have been watching them because they've been submitting written comments after they've been reviewing it. For the Kalawa meeting, we decided to only go with one consultation because for the last two regional plans, they have had a priority project that talks about renewable energy development at the particular site that we solicited. So basically the community has been on top of this from day one. So in 2009 and 2020, their regional plan updates reflected that priority project. So we wanted to wait until we had a developer to come and talk with them. So we had that meeting on the 13th of July, and we did bring the developer with us. Again, small attendance. We had actually invited 975 lessees and applicants that reside in the Kailua Kona zip code area. When we have these meetings, the first thing we discuss is why is Hawaiian Homelands involved in renewable energy development, right? Why in Kauai, or why in Kalawa, why now? And exactly how does it work? How is it that DHHL gets involved in renewable energy development? We start with our energy policy that was passed by the commission in 2009, and it has several objectives. And one of the objectives talks about looking at the potential of our lands for renewable energy development. But the overall policy is saying that we want to enable and put Native Hawaiians at the forefront of, you know, energy self-sufficiency initiatives and sustainability, that's a rightful place for Hawaiians to be in. In 2015, Governor Ige signed into law a game-changing law. This changed the whole landscape. But what it requires is that electric utilities must produce 100% of their electricity, 100% of their electricity through renewable resources, renewable energy resources by the year 2045. 100%. So that's game-changing. That, you know, we were kind of dabbling with it a little bit here, a little bit there, but this basically set this for, you know, a lot of demand and a lot of renewable energy developers coming in to look at how can they help to meet this demand. Another reason why we get involved is because, as you know, we have needs. So this becomes revenue from general leases and to fund our continual development of homesteads. And the other thing is we have trust lands that actually have the resources. We have strategically placed trust lands that have excellent renewable energy resources. So that's kind of like the reason why we get involved. Oh yeah, I was gonna report that at the end of 2020, we're at 34.5% renewable. So to get to 100, we got a ways to go, right? And at this point, at end of 2020, 1 out of 3 homes had solar power in some shape or form, which is interesting. But what the company is saying, that means that 2 out of 3 didn't. And so that's going to set up the stage for community-based renewable energy. So let's look at our lands. You know, this is a quite high piece. It goes all the way up above the mountain road area. And when we look at solar radiation maps, looking at the solar resource itself, we see that this area in, you know, the darker orange has high potential solar resources, and this is where our lands is. So let's go get down, and so we can look at this area. So here are our land use designations from our island plan. Just to give you orientation, here's the harbor. This is the Konipule Road coming up, and then this is the Kailapa homestead area. This is our industrial lands where we have our general leases. So it's right before you get to the industrial lands. There's a vacant piece over here that we're looking at. And it was designated for commercial use. See, there's 91 acres total in that pink area, but this parcel that we're looking at only occupies 21 acres. Right? It's the one that fronts the Konipule Highway. And here's a nice just close-up of that, and you can see the industrial area is starting. We're just getting into the industrial area. So that's that site for Kaihai. For our Kalawa lands, we have 3 parcels. It's basically right across the airport, right? But the parcel we're looking at is this one. When we look at our island plan land use designations, these are the designations for the land. So in this large parcel is 200 acres, but half of it was for industrial. Right? We're not going to fool around with where we had residential, but this looked very viable. And this is the site that, of course, the community had already identified through 2 regional plan priority projects. This site is right across the Nelha entrance, that intersection. It's right on the main drag. Okay. So now you can see this area. So that's what we put out for solicitation. We put out a thing saying anybody interested in doing renewable energy development on these parcels. And that solicitation went out in August of 2020. So when we get involved in renewable energy development, it gets complicated because there's so many players. There's 3 players, right? There is the utility, and this is the one that needs to do the 100% by 2045, right? And they know that they can't produce all of this. So what they're looking for is to buy the renewable energy, right? To make that quota. They do that through an instrument called a PPA, a power purchase agreement. And that is directly, it's like a contractual agreement with the renewable energy producer, which is the second kind of player on this table, right? Our renewable energy producer is Next Amp Solar LLC. But what these guys do is they have the technology. They know how to turn sun into electricity, right? So they have the technology down. What they don't have is a location to do it. So what they're shopping for is they're looking for land where they can do their thing, they can generate energy, and they're looking for a purchase power agreement with the utility, which the utility is saying, you make this much energy, we're going to buy it from you at this rate, right? So that's what they're looking at on the 2 sides. We're, of course, the landowner. We come in a landowner position. We don't have a direct relationship with the utility. Our relationship is with the producer. And the way that relationship is codified, I guess you could say, is through a general lease, right? We lease the land to the producer. So, and from that, we get general lease revenues. So we come with 2 things. What I tell people is we have land and we also have beneficiaries. And so, yes, we're concerned about the general lease revenue, but we are also concerned that projects are going to be, minimize adverse impacts to our community, and that our community gets adequate community benefits out of the project. Some of the benefits that we've been able to kind of get them developers focused on is to help implement regional plan priority projects. Of course, workforce training is always in the mix there. But everywhere we go, and every time we talk about renewable energy, there's one thing that always comes up from our beneficiaries, and they say, why don't you just pay for our bills? Why don't you just lower our electric bills? Right? And I used to think that, well, that's kind of, I mean, that would be great if they could do it. But I never thought we could actually do it. And here we are, we're in a position where we can do it. So this is the same three actors. I'm putting it over time so that you can see that the complicated part about this is that not only are there three players on the table, but we are each manning our own systems and processes, and somehow we got to connect, right? So we have to be very aware of what is HECO doing. Even our relationship is not with them. We have to know when they're going to drop their RFP and when their deadlines are coming, because we need to make sure that our renewable energy developer has site control, paperwork, and documentation, right? So the coordination of the three processes is what brings up a level of difficulty. So we start our process. We put out put out a solicitation for proposals. The developer responded, sent us back. We reviewed it. We selected one. That's where we are right here. This star. We selected the best proposal out of the bunch, and we're going to be conducting. We did our beneficiary consultation meetings, and we're now going into our public hearings. Let me explain. So, in order for us, as we have public lands. In order for us to use public lands for renewable energy development, we have to follow the statute 171-95.3. And what that says is that we can negotiate agreements for renewable energy development, but we need to do it and we need to have 2 public hearings where we inform everybody about what we're doing. We need to have it be an open process. In other words, anybody can apply it. So we put out their solicitation, they could send us their applications. And the applications have to have certain information presented. And we have to present that information during the public hearings. Public hearings are supposed to be conducted on the island where the project is located. And there are your public hearings commission. So you're convening the public hearings. And members of the public are able to get information and to comment on the project at that point. So what happens is, meanwhile, the company is dealing with HECO. So what has happened is that for over a year now, they have had these draft RFPs for this process. And for whatever reason, they have not dropped the final yet. And so we're all sitting and waiting, trying to figure out, okay, when is this stuff going to drop? Because once they drop the RFP, they have like a month to turn in their proposals. And part of that proposal needs to show that they have site control. So our job is to equip our developer with enough pala so that they can demonstrate site control when it's being called for in terms of the HECO process. So for us, we'll be doing our 2 public hearings, and what we're looking at, how we usually do this is we will issue a right of entry agreement for 2 or 3 years, and they can extend to 3 years, for them to do their due diligence work. So this is when they're going to do all of their studies, their environmental studies. They have to come out, with an environmental assessment. They're going to do the study biology, culture, archaeology, and basically come in. We're going to come in at that point with, the draft EA, and then the final EA, which the commission approves. So there's a decision on the right of entry and a general lease. How this works is the right of entry is for due diligence. If they get through due diligence and all of that is great, then they can the ROE converts to a general lease. Okay, so once we do this decision, then we don't have to come back. We can just figure out, okay, well, whether they complied with all of the conditions of the general lease. Okay, the compliance, the major hurdle in compliance is getting through the EA, FONSI, right, and getting all those studies done. So these are major decisions the commission makes. After that, after they comply with the Chapter 343 environmental assessment, then the lease will kick in, and then they can start doing their financing and construction. And part of the the requirement is that they need to get a PPA from the utility. So that's built into the lease agreement. So that's kind of like the managing the processes. And as if that's not complicated enough, there's another thing now called community-based renewable energy. Real quickly, this is the easiest way for me to explain it. It's just animation thing, right? So this starts with houses that have been able to put a PV panels on their houses, on their roofs. They're happy, they're hooked up to grid. If they don't get enough energy, they still can pull in what they need, and they hook and they're happy because their bill is like very nominal. It's like $20, right? Just to keep the lines open. But what happens is there are people who live in apartment buildings who don't have roofs. And there are people with roofs that can't afford to put up PV panels. And these people have not been able to participate from benefiting from renewable energy development. So HECO has figured this out, and they have come up, and these guys are paying a very high bill. So HECO has come up with this new program called Community-Based Renewable Energy to address this. What the goal here is to get people who haven't been able to benefit from renewable energy to be able to benefit from renewable energy. So how this works is there is a third party, which is they call a subscriber organization. But this is actually the renewable energy developer, right? The third party on the table. They're required to have a site. That's the site control. And on this site, they're going to develop a solar project. Actually, they could do wind, they could do another one, but we've only had solar projects. So they're going to develop a solar project. This project will go directly to grid, right? It'll hook up directly to grid, and that way we're contributing to HECO's goals of having so much renewable energy. The difference in this is that this developer now, or the subscriber organization, signs up subscribers. Subscribers are those that, remember, could not participate and benefit from renewable energy development. They live in apartment buildings. They can't afford, they're renting a house. They can't afford PV panels. So those are your subscribers. They sign them up, and they give that list to HECO. So every month when HECO cuts the bills, they're going to have a list of subscribers, and they are going to be given a credit on their tax bill, on their electric bill. So when they get their monthly, the subscribers get their bill in the mail, it's going to be reduced by say 10 to 15%. That's because they're subscribers. Now there's different configurations on this. Some people have the subscribers got to buy in, like they're going to be an investor in the model. They have to pay up front. The ones that we're looking at don't have anything like that. We don't have any kind of credit checks or any kind of fees that go along with it. The other thing I want to, there's another little caveat there, is that HECO has, in order to get these companies to cater to these people that normally don't benefit from this, which are, they've come up with this low to moderate income category. And they've incentivized the developers to say, if you cater to this group, which is they're defining as 80% of area median income or less. If you service these guys, then we'll help out. And so they're going to, they'll pay for the interconnection fee, for instance, right? They'll waive certain things, but the company first has to decide, are we going to be a low LMI project or not, right? Because it's different. So for the ones that we have that, and we, the company that we selected is called NextAmp Solar LLC. And it's interesting, they submitted the 2 proposals for Kwaihai and Kalawa, and they're both selected as the developer for both parcels. They're founded, 2007, high school friends got together to do this company. Over the years, they've been able to, do a lot of projects across the United States. They have, and what they do, it's interesting because they have these turnkey projects exactly this size. They're not doing like huge, they're doing like 3 megawatt projects, and they just do a whole bunch of them. They know how to do that in backwards and forwards, right? They know how to do this. What attracted us to this developer is that it's a long-term owner developer. They stick with the project all the way. So it's not like they're going to sell it, they're going to get the paperwork and sell it. They're actually, you know, in for the long haul. They're also backed financially by actually the Mitsubishi company, a subsidiary of Mitsubishi, is backing them. So they have this financing in place. So they've decided to do the low to moderate income type project. So these are the income limits. It's 80% of AMI for Big Island. And based on what they're looking at, quite high, they're going to be developing a 3.9 megawatt system. And this is their math that they come up with. So that can host 500 homes. In Kalawa, they're looking at an 8.4 megawatt system that can host 1,100 homes. And they say it like that, but it's not really like hosting, like they're not going to hook them up. But this is basically the subscriber base. So what they're looking for in High is 500 subscribers that meet that low to moderate income requirement. What they're looking for in Kalawa is 1,100 subscribers that meet that low to moderate income requirement. So that's what we're looking at. At that point, we can already say that's more than the amount of houses that we have in those areas. So what we've been looking at, and this is the thing that's game changing for me, is that for the first time ever, we can offer community benefits that extend into our applicant database, into our applicant pool. The only requirement is they have to be a resident on island. So anybody on Big Island, right, can sign up to be subscribers. And I think I'd have a slide up here, but the subscriber base is managed by HECO. They have a website you go to and you kind of, you know, look for all of these CBRE projects and you're going to sign up basically. But this one will give preference to Hawaiian homelands, lessees, and applicants. And so this is something we can, you don't have to live right next to the power plant to get a benefit, like how normally the benefits work. Anybody on island can get the benefits, but they need to make that LMI requirement, low moderate income requirement. And as you know, a lot of our lessees, I mean, they have mortgages, they have good credit, they have income. So some of them will not be able to get it. And the other thing is that if you already have PV panels on your house, right? If you already got it together and you have it, you're not going to be able to subscribe. So even if we cannot absorb all of these, 1,600 subscriptions, they can also go to nonprofits and others, or to general public who can make the low to moderate income requirement. So we took this out for consultation. Oh, one more. So here's a picture. So remember this parcel in High. They're showing what they're going to do with it, the layout. This is how they get their 3.9 megawatts in High, and then this is their Kalawa one. What they're looking at is not the whole 100 acres here. They're just looking at 28 acres, which is in the red area. And their sensitive equipment, where they hold their battery banks, these are solar plus battery projects, would be internally in the middle of the thing, so it's not like exposed so much. Then here's a picture of they use these tracking ones that actually track the sun over the day, and they're elevated up to, so this is exactly the same ones that they'd be using, but it goes into the ground about 5 feet, I guess they're saying. I thought it was interesting. They said that, HECO will bring in the certain connections that come in, but other than that, there'll be no wires. Everything is underground. I thought that was great. And then they have pictures of their battery area, battery bank, and their monitoring system, because they can they remotely monitor all of their their systems remotely. So it's very low maintenance, not a lot of traffic kind of thing being generated. It kind of runs itself. What they have been doing is trying to get they've been working with the sheep farmers because they're doing a project on Oahu. Because it's really good for them. They don't have to go and lawnmower the grass, right? And then they can say that they're contributing to agriculture. They've looked at putting in pollen bee habitat, and trying to make multi-use off of this solar panel. So there's shade, right? There's grass that can grow, and so they've had certified wildlife habitat that they put under these things. And basically, they said they can grow anything that doesn't require a machine to harvest, that doesn't require so much sunlight can go under here. But they're interested in hearing what other kind of uses our beneficiaries might have, ideas on what else it could be done under the panels. And so, to sum up, what they're presenting is the community benefits for 20 plus years, that they would have a monthly discount on their bills for about 10 to 15%. Priority will be for Hawaiian Homeland's beneficiaries. Of course, they will upgrade the infrastructure, for the electrical infrastructure. The workforce opportunities, there will be there, but they're saying, it's really a low maintenance operation. So it's really construction part and some maintenance, but not a lot of jobs. They would donate to nonprofits that serve homesteads, and they want to help agriculture in terms of, like what goes underneath. And they say that they're very low impact conservation use of land, that when they're finished, they just lift them up and they're gone. So that's the summary of that. Okay, I just wanted to point out, there's no upfront cost. There's no, they make it really easy. There's no credit check. There's no long-term commitments. It's like, if you need to cancel, you can cancel. They want 90 days notice. It's pretty easy operation. This is the website I told you about that HECO is going to be maintaining to sign up subscriptions. What Next AMP says is that they can certainly sign us up too. If you guys don't want to deal with that, they can input your name. But this is the way that you can see all what else is happening with the community-based renewable energy projects that HECO will be doing. This is Next AMP showing that they work with communities, that they have these ways to contact their subscribers, and they have a little welcome kit when you're a subscriber, and it has a guidebook as to how to use the subscription and stuff. So I just wanted, in closing, after our meeting with the beneficiaries, there were some issues that were raised, and they're concerned that
Julie, you need to clarify which community you're talking about.
Okay. So I kind of mixed them up together because they're all very similar. The basic concern is that they feel like a lot of them won't qualify for 80% or below, that our people are making too much money or they're financially stable, that they would not be able to qualify. So what their concern is that somebody else, a non-beneficiary, who is low income, will be able to get this break in their bill, a reduction in their bill, but they're non-beneficiaries. And so they're saying, what about us? There's other beneficiaries that are saying, we already just invested in our PV panels on our rooftops. And now we can't participate in this. So we're not getting any benefit. So I think that's the main concern, is that they feel like people would not necessarily meet the 80% area median income. That's their main concern. So they're talking about opening it up. It should be all income, and it should be all just beneficiaries should benefit from it. I don't think they have that latitude. It's a HECO thing. HECO's coming up with this requirement of this target group. They're saying there needs to be an incentive or some other way that people with PV panels can sign up so that they can benefit from this. That's the main thing, is they're concerned that not everybody's going to be able to benefit. There's other kind of things about whether businesses can sign up, whether they could come in under this program as a Hawaiian business. On the workforce development, I thought it was a really good idea. Our La'iopua 2020 executive director was saying, hey, I got a facility And I wouldn't mind helping out with workforce training. You guys can train in my facility even, but come up with a plan. Show us what is your plan for workforce development. What are you going to be providing? How to, so that we can get our beneficiaries involved in it. So they wanted to have more information about really what they are planning to do. They wanted more information on this nonprofit donations to nonprofits that serve homesteads. Like, how does that work, right? Who are you talking about? Are we giving you guys names of organizations that you're gonna donate to, and how is that all gonna work? They wanted to have more details so that it can be more real, right? Instead of just saying, yeah, we're gonna do this. And that's, yes, those are the areas of issues, basically. I think they felt that 10 to 15% reduction in bills was not a lot. There was one idea here, number 4, where, well, maybe you can start like at 25% and work yourself up, but get to 50% reduction in bill. Let's talk then, like that's
Mr.
more
Chair.
significant.
Mr. Chair, thank you. I don't mean to be rude, but I will have to interject. I have to leave. I have to tap on to do my neighborhood board meeting, Mr. Chairman. I'm
Sorry.
asking to be excused.
Yes, thank you.
Thank you. Thank you, everyone. Thank you, Julie. Thank you.
I'm sorry, I thought it was doing this
No,
fast.
no. I'm sorry. I have to leave. Thank you very much.
Okay, aloha.
Yeah, that's about it. The last thing is we still don't know when the RFP is going to be released. This is the last schedule that it came up with, and we're far beyond that at this point. And every time I check, they say they're going to come out with it anytime. So we're just waiting, but we're actually way ahead of the curve, as it were. So usually we're rushing to try and get under this deadline, but so it's been good to be able to take a breath on this and have some time to talk with them and to have these consultations. So that's been good. So next steps in the second week of October, you're all online, right? I know that let's talk with you folks about the public hearings that we need to conduct. And I need to clarify, so there's 2 public hearings per project, and we have 2 projects. So we're sitting down for 4 public hearings, 2 each. And then the last day we would actually convene for the decision making on the right of entry conversion to general lease land disposition. At that point, the due diligence period starts and they can start doing their studies on site. They would have the right of entry agreement that would suffice with HECO as demonstration of site control. We think, it's basically a land disposition. HECO, we're still waiting for them to release the RFP. At that point, next up, we'll have to apply and we'll have to secure the PPA. So there's a lot of ifs in that mix, but that's kind of like what would be projected in the next steps. And that is it.
Okay. Thank you, Julie. Any other comments?
Just that we have the motion to accept beneficiary consultation report.
Yes. Okay.
And I didn't present it like the submittal, but
Thank you. Thank you, Julie. Can we go back to the screen?
I'm gonna release this as soon as I can.
We need to make the motion. Okay, commissioners, I need a motion to accept the beneficiary consultation report on Kalawa, item G5.
So move.
Randy?
Second.
Mike. Okay, thank you. Any further questions on the beneficiary consultation report? Okay, if not, all those in favor say aye. Oh, wait, stop. Mike, was that your hand or were you asking a question? Yeah, question.
Yeah, I have a question. Yeah, so thanks, Julie, for explaining that. So yeah, Hawaiian Electric's goal on this CBRE program is really try to help out the folks that can't afford to do their own rooftop solar, right? So I think it's a great program and initiative, and there's a lot of opportunity. I was curious about a couple things on the 88% MI. Do we have information about how many beneficiaries we have on island? that would
Oh.
meet that condition?
You know, what we have is our beneficiary studies that we do every 5 years with SMS. And that's the only place that I could find this. But so we have a percentage amount for the applicants that we know are 80% or lower AMI. And we have another percentage amount for lessees that are 80% or less. And it's generally about 50% is what we're finding out. But this is, you know, it's a general statistic. It's not a fine-tuned, you know,
Right.
data point. Yeah, it's just a general kind of, if I needed to estimate, that's what I would use.
All right, thanks. And on the, with regards to the, you know, you had the nice chart, the flow chart with the PUC. So we're waiting for the PUC to issue the final RFP. And then I saw the next step, it says land position. So my question is, do we, the commission, need to approve the ROE general lease to satisfy that land position requirement at the PUC level?
We have asked they have a, I don't know what they call it, where we can submit questions. So we've submitted a formal question to say we did selection letters. We selected Nexamp for this project.
Right.
Would this suffice to demonstrate site control? And so we have not heard back yet. But we're trying to see if that suffices, then we're off, you know, we don't have to do anything. But yeah, but they still, I know they want access to articles so they can begin their studies, right? And they have a drop dead. I'm sorry.
Sorry, to answer your question, Commissioner Kalikini, it would be better for NextAmp to have a right of entry from the commission for their application process.
Okay, yeah, thank you. Wait, one last one. So you were showing the site layout, etc. I was just curious if we are aware, is there any provision to perhaps consider like expanding the amount of you know, energy at the locations? Is that something under consideration?
Yeah, actually, for the Kalawa site, right? That was the 100-acre site that we put out in the solicitation. They were only like showing us a little square, but their proposal actually had, you know, wanted to go into another phase of kind of more development. And we said that, you know, we couldn't entertain that part. Our solicitation was, you know, was clear on what we were looking for. So it's still on the books there. You know, they put it as part of their proposal, and, you know, I'm sure they'd be still interested in pursuing it because that there is more land available there. But they understand that we're equipped to kind of handle CBRE right now.
Okay, no, thank you very much. Very informative.
Any other questions? Okay, we have a motion to accept the beneficiary consultation report. All those in favor say aye.
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 Thank you,
None
commissioners.
opposed? Seeing none, the motion carries without the two commissioners. Yeah? Okay, go to G5. Commissioners. Oh, sorry, G6.
Chair, if I could.
Yes.
I'm going to sign off. I have other commitments, but I do want to say that I think the department creating an agenda that is so crowded where we're still in deliberation, it's unfair to the commission and it's unfair to the beneficiaries. And I say that because if the department is not creating an environment where we can give our full attention to these very important matters that require our focus at this time of the day, for me, I don't think that's an environment that properly serves our beneficiaries. And I have other commitments now that I have to attend to, so I won't be able to be here for the whatever presentations are left. So
thank you.
Okay.
Thank you, Randy. We'll endeavor to work on the agendas in the future. Today, this commission meeting was an experiment because the commission wanted to hear the public testimony in the J agenda prior to the decision making. As you can see, that took up a lot of time. I think going forward in the future, the public testimony definitely before any decision-making on an agendized item. I think I will review the J agenda, possibly going back to the schedule that we have after scheduling important decision-making items prior to that. And then I would just add that I think we as commissioners, we need to exercise some sort of constraint, I think, about the number of comments that we make. And that would
Yeah,
have.
I don't, you know, William, I don't agree with that. I don't agree that we should constrain ourselves on the kinds of questions we are asking, because
Not the
that's
question, not the questions, Randy, the comments and the congratulatory statements.
I'm not sure what you're,
I want
I'm not
to
sure
have
what
as
you're
much time
referring
for
to.
questioning. I've been observing in the past couple commission meetings, oftentimes we spend a significant period of time congratulating applicants, congratulating folks that put their programs forward. I think with some constraint, we could cut down on the amount of discussion and get to the business in a more efficient manner. That's all I'm saying, Randy.
Well, I'm not really sure how to measure and quantify that comment, because I've not paid attention to the amount of time that it took and how many people did congratulatory comments to create a situation where we are still here. What I am saying, Chair, is that we could see before we even assembled that this is going to be a very crowded agenda. And we're getting documents sent to us as a result the day of, and they're pretty lengthy and extensive documents in some cases, where if we were to do this properly, we should be able to read through it as part of our deliberation. So I don't even know how to quantify that statement you are making. And if I could, William, my observation was a lot of the interaction that was occurring with certain commissioners is the result of meetings that occur prior to our arrival here, where our beneficiaries, one of the benefits of making time to sit with communities, one of the benefits are that certain contentious issues get resolved before it even comes before the commission. That said, what is left, there's an expectation that what is left is that we engage the department in such a way that we are seeking clarity, that we are advocating for them on matters that they feel are still important. So what you don't see is those matters that have been mitigated and resolved before it gets here. So my recollection of yesterday, for example, were a lot of questions that were coming up to gain clarity so we can take it back to our communities, to represent them on matters that they felt were important. I just am going to maintain, William, this is a crowded agenda. It's not fair to Julie that she doesn't have my full attention because it's been a long day. She did a very good report, but I had trouble staying engaged. So again, I don't think the creation of this situation is fair to the commission and therefore fair to the beneficiaries and therefore fair to the staff that wants our full attention. So I think I'll end it there. Thank you.
Thank you. Thank you, Randy.
And Chair,
Yeah, Zach, I know that you have to take off.
I have to go. I get Kuleana. The DHHL is turning the water off tomorrow all day. They have a huge repair that they gotta do. So I get some kuleana outside before the sun go down, so I gotta go.
Okay,
So, you know, I mean, it's been a long day, so you guys have a good evening.
mahalo.
Hey, everybody. Ahoy ho, malama
Your,
pono. Thank
your
you,
attendance,
Julie.
your,
Aloha.
your attendance and participation is much appreciated. That leaves us with 5 commissioners. We have one more decision-making item to go. The other items can be deferred. Can I ask the other 4 commissioners to hang in there for the final decision-making on agenda item G6, which Judy, I think, has presented the majority of the information as far as the beneficiary consultation. And I think we could actually move to accept the beneficiary consultation report regarding Kauai High. I have a motion.
So moved.
Second.
Okay, it's been moved and seconded. Any additional questions regarding Kauai High?
Yes, I do, Chair, and I know I'm gonna upset you, but
Go ahead.
I want to ask Julie on the HELCO requirement that we go with some percentage of AMI for the people who can subscribe. Given the unique circumstances of the facility on Hawaiian Homes, can we negotiate that with them to say, we know your program, so we'll try and get as many beneficiaries who qualify, but then the next tier is we overflow into those that are beyond that, so that we can get fully subscribed for these credits.
I always think that we're special and that we should have special considerations. But you know, we have to have somebody that can be able to go to bat for us on that. It's the PUC as well. You know, they're monitoring HECO, and so between the PUC, we've actually thought of we drafted letters to the PUC to try and explain how we're very different and how our requirement to meet statute, the public hearings and everything, nobody else has to deal with, right? None of the other landowners have to deal with that. So they can respond in a minute, right? And show site control. But we have to do all of this public stuff that we're required as a public agency. So we should get special consideration when it comes to how, you know, how we're processing our company, our renewable energy developer. The other state agencies haven't really done this yet. We don't know of other state. I think maybe HCDA just started doing it, but you know, we're the ones that we've already participated in several of these RFPs.
Let's not take time today, but let's work with council, hire council that know this area if we have to, but let's try and pursue that. I think so.
We do have a contract for renewable energy consultant that does advise us. So maybe that is something we can look into.
Thanks. Thank you, Chair.
Yeah, Russell, thank you. We can always place conditions, and if the PUC or HECO or the proposer of the project doesn't like those conditions, they can go elsewhere. And we have that power. So if you want to set conditions in the lease that says something other than in the HECO RFP, just understand that we're taking a risk. So, but we can, if you want to. Okay.
Sure.
Yeah, Mike.
Just a quick comment. I can, to Russell's comments, I can reach out to some folks at Hawaiian Electric and go explore this 80% AMI and see if there's any options. So I'll volunteer to do that.
Okay.
Great. You have a connection.
I know a few people.
All right, Mike. And I would also ask that there's probably some tax credits that are also intertwined in this. So if you could flesh that out for us, be good to understand.
Will do.
Okay. All those in favor? Say aye.
Aye.
Aye. Aye. Motion carries. I am understanding that you all are tired. There was one more important cesspool discussion, but I think we can defer to next month. Okay, I got the okay from the one who was standing here all day to give you that presentation. With your permission, can I have a motion to adjourn?
Chair, how long is that presentation? We're all here. I don't know. I'll like go home too, but I'll like get through the important stuff. I don't know about the rest of the commissioner, but
I can stay.
Yes. Stuart, how long is it? Stuart said he'll do it in 5 minutes. I don't believe him, but we'll try.
hey, we'll give him 10, but let's hammer.
All right. Thank you, commissioners.
Thank you.
Right on, Stuart.
Oh, it's
What's
Stuart.
the item? Chair, what's the item number?
I'm sorry?
What item
Item,
is it?
item number is E2?
E2.
E2.
E2. Okay.
Aloha, commissioners.
Aloha.
We had our consultants on the call, but I believe they may. So I think Fukunaga and Associates were hanging on by threads. So mahalo for that. But what I'll do is I'll go through the submittal which you have and just kind of highlight the points there. So what we're trying to do is take that deep dive into cesspool. So we're saving the best for last, yeah, for you folks. You know, wastewater is continuing to be a huge item that is involves not just cesspools, but septic systems and sanitary sewer systems. So you have seen in some prior submittals that we've engaged consultants to start designing sewer remediation. We're looking at Papakolea, Waianae, Nanakuli, Waimanalo. So what this does is this submittal focuses on providing information regarding cesspools. And so the big statement here is that there is state law that requires cesspools to be replaced statewide by 2050. And that was Act 132, Session Laws 27. So you have that in the submittal. Also, the submittal points out that estimated for cesspools on Hawaiian homelands is about 2,500 cesspools. So what we wanted to do was to provide to you what the plans we have going forward. And I think that's the main thing we wanted to share with the commission because we have consultants ready to engage communities on Oahu, in Nanakuli, in Waianae, and in Waimanalo. So the first thing that we have planned is to send out a survey, what you see before you, which the PowerPoint is also included in your packet, where we understand cesspools to be located in Waianae, in Nanakuli, and I think the following slide shows Waimanalo. And so our intention is to send out a survey to the lessees there and to confirm the existence of cesspools. We know that not all lessees are going to respond. And so the second phase of the study will look at the on-site surveys, ground truthing, etc. And it may be physically going onto the lot or using drone technology or both. And basically we want to verify the cesspools, its location, look at the areas whether it is currently sewered or not sewered, and what it'll take to remediate the cesspools by replacing them with individual wastewater systems, which are septic tanks or aerobic treatment units, or some other form of sewer line construction, which could include lift pump stations, low pressure sewer systems. And that's some of the things we had shared earlier in Papakolea, what some of the challenges are because of the topography, because of the age of the systems, the proximity to the city or the county's sewer system. So that's all part of the study. What we wanted to do was to share this information with the commission before we unleash the Kraken and send out our consultants, send out our mailings to the community. So we didn't want to really alarm them because, you know, there is a 2050 deadline, but, you know, we want to get a jump on this so that we're not caught behind the 8 ball. We're looking at various low interest loan programs. So one of the ledge proposals is to establish a low interest loan program to assist lessees. We're also looking at different programs with you know, that could provide grant assistance. So some of these conversions from cesspools to IWS or to sewer connections, you know, will cost, you know, anywhere from $15,000 to maybe $50,000. And so that's a huge, you know, chunk to, you know, for especially like our older communities and our, you know, kupuna to, you know, to weather through. So we wanted to kind of give you that global picture. We also have consultants ready to go into Molokai properties, particularly the areas along the South Shore because of you know, climate change and sea level rise. So this is one of the priority areas. Also, Keokaha in Hilo is another priority area. And you know, not only the areas around the coast are affected because we have right now in Waiahuli, we have a large number of cesspools, which according to Department of Health are the leaching is affecting potential groundwater sources. And so, you know, with our planning office really you know, taking bold steps to secure water with water commission and all of that. And, you know, these are areas that, you know, potentially in the future can provide groundwater resources for our, you know, expanded, you know, programs over the next, you know, umpteen years, you know, after I'm gone. So, but we want to get this in place, and you know, with the help of our planning office and our consultants and our district offices, we need to get out into the communities and start these surveys so we can get ahead of the game. And so we wanted to bring that to you. I just kind of whipped through that. Appreciate the 10 minutes. I think I might be close to that. And your stamina is to be commended. You know, we have our consultant from Fukunaga and Associates, that's Wei Chen. You know, kudos to him for preparing the PowerPoint. And you know, he's really passionate about this whole thing. So if you do have any kind of technical questions, he's stayed long as all of us on here. So if there is anything, I would be happy to have weigh in on it. So I think what we'll also have to do is to touch base with Commissioner Teruya, because the areas in Waianae and Nanakuli will be soon on the calendar for mail out. So we're working with ICRO on trying to fashion a vehicle or a mailing that's easy to understand and not overly technical, but just really trying to get the word out into the communities.
Go-
Stuart,
Pauline, and then, go ahead,
yeah,
Pauline.
Stuart, I didn't have a chance to talk to you about Papakolea. So when would you be doing that, and Waimanalo?
Okay, Papakolea is all sewered right now. And so we have a sewer master plan. We did one phase of the construction. It was about, I think it was about $15 million. And so we have the second phases under design right now. I think we did a presentation several months ago. And yeah, so we're gonna keep pursuing that. Yeah.
What about Waimanalo?
Waimanalo is on the list, which Fukunaga is going to also start the notification to those lessees who have known cesspools. So Waimanalo is on the program to be notified along with Nanakuli and Waianae. The other homestead properties are sewered already. So there may be a few stragglers here and there who are not connected, but our main purpose for this one is to start the research on the cesspool for cesspool closures.
Thank you.
Mike, and then Russell.
Yeah, real quick, maybe Stuart or Wade. So the conversion from cesspools got to be done by 2050, but I saw you had on there there are exceptions. What are the exceptions?
I'll forward that over to Wei.
Yeah, I think exception would be maybe they will the C will get the approval from the DOH director. They can still use the cesspool, but I don't know what's the criteria.
Okay, I was just curious. Thank you.
Maybe we can, as part of the study, ask that question and see if they have designated criteria.
Yes, that'll be helpful.
Sure.
Russell?
Stuart, thanks for the quick presentation. So in those neighborhoods where we have to replace aging sewer facilities, are we trying to collect the expense of that from the affected homes? Or do we basically eat that cost as the landowner?
We are, yes, we are eating that cost as the landowner. The sewer lines that we are remediating right now don't meet the city and county standard. So I think it was maybe a year ago, we shared what we had.
Yeah. No, I understand. But my question is, so how do we now propose in for those that are currently cesspool and we need to upgrade to septic, other than the fact that it's gonna, how are we gonna pay for it? But how do we justify passing on that cost to the tenants, to the lessees?
That is a great issue that we will need to deliberate. And so we're looking at different sources of loan and or grant funding. There are different programs. Nancy has been working with different nonprofits on that. And so there are also some pilot type projects. There's also new technologies that are being looked at and in coordination with Department of Health to look for lower cost, exceptions to a full-on conversion to sewer.
Right, but you mentioned that there might be some concern for Kupuna and others who we're trying to let them know there's this cost that's coming that has to be incurred, but if the department takes on that cost,
I don't think we can, I don't think we can afford to take on that cost. I don't think we have enough money in our trust fund to do that, Commissioner.
Right.
I mean, the costs are going to be incredible. And at the same time, all of the fee simple folks that are in the same situation are going to have to go through the same conversion if this mandate continues on.
But not people who, not leaseholders lessees who are currently hooked up to sewer. But
Correct.
we have to improve the sewage. And it's because one is a county requirement and the other is a federal EPA being pushed through the DOT.
That's
No,
correct.
sorry, Department of Health, DOH.
That's correct.
I don't see the logic, to be honest, but I understand the financial realities.
Commissioner Kaupu,
Yeah.
so the sewer line remediation, we're using state general obligation bond funding. So we have R&M Purpose 4 funds appropriated from the legislature for that. For those, once we correct the issues, then we can, those are the ones that we turn over to the city for the city to then forever maintain, going forward. So that's another, that's separate from cesspools, but once we get some of these sewer lines remediated or upgraded, then we can take on the connection to the sewer systems from existing cesspools. And so, in the past, the commission has appropriated funds to provide septic systems in Wai'ehuko. They provided it also in development projects in Lalamilo. So there is some precedent. So what we can do is to share with the commission all of these different situations that have come up, and then start, once we have the assessment of the existing cesspools and what the magnitude of that is, then we'll need to get back to I think both the commission and the legislature on that.
Right, and the magnitude is what we and his group are going to be doing, right? This survey and this study.
Absolutely, yes.
Yeah. So, yeah, I agree. So, thank you, Chair. I'm ready to vote if nobody else has questions.
Okay.
This is an information submittal, but your vote of confidence is greatly appreciated. And we wanted to share this with you before, so you hear it first before we go out into the communities, and there's all kinds of,
Yeah, you get those emails
yeah.
like you're getting the SIC ones now. So I'm gonna
Chair,
prepare
I have
you. Go ahead, Dennis.
Yeah, is now the septic system, or not septic, but the cesspools. Who owns the cesspool? Is that an infrastructure or is that the lessee?
That is lessee's responsibility. Same with individual wastewater systems, the septic tanks.
Yes.
Yeah.
So the ownership is the lessee.
It is, yes.
And let me add one more thing. And the likely requirement from DOH to fill the cesspool with some substance to, make it safe is also the lessees.
Right. Okay, thank you.
Okay, thank you, Stuart. Thank you, Nancy. Commissioner Ka'apo is back.
Hello, I'm sitting on the plane. I'm just listening.
Okay, okay. Did you have any questions about cesspools?
Only if it doesn't require me just to talk about doo-doo.
It's duty. It's your duty.
Also, we have a consultant to do the same research on Kauai, in Anahola and Kekaha, where we do have cesspools. I think there may be some within the farm lots if they started prior to the mid 1990s.
Okay. Want to thank commissioners for hanging in there and apologize for keeping you out late today and yesterday. And I really appreciate the humor. I know that everybody's fatigued and there's a little bit of frustration, but I know that you guys do what you do, not for the big money that we pay you, because we don't pay you anything, but rather for the satisfaction of doing a difficult, complex, and many times not so rewarding job. So I just want to say that as we ask for a motion to adjourn.
So moved.
Second.
Okay, all those in favor say aye.
Aye.
Aye. Aye.
Okay, thank you, Wei.
Thank you.